Bless you. Madam Clerk, I'm ready when you are.
William J. for the state.
James Owens on behalf of Sarah Boone.
Tony Henderson, Sarah Boone, Kevin Beck.
I do.
Ma'am, good morning. Can you please state your full name and date of birth for the record for me?
Sarah Boone, 10-10-77.
All right. Ms. Boone is seated at council's table, wearing a black suit and a pink blouse. She is in custody in this matter. However, there are no restraints that are affixed to her person. So we will be standing when our jury enters and exits. Before we bring in our jury this morning, yesterday the court had reserved on a Richardson hearing regarding Exhibit 2 as identified in the defendant's fifth amended reciprocal discovery exhibit list, specifically 119 pages of records from Advent Health Winter Park that were provided to the state yesterday morning by way of USB drive. Yesterday, the court had ordered that the defense was to provide an edited version of only the records pertaining to anxiety and the lack thereof, or anything pertaining to those matters, but before 9 a.m. this morning. Was that done, Mr. Owens?
Yes.
Okay. Mr. J, have you had the opportunity to review the culled down list of 119 documents?
Yes, sir.
Okay. What is remaining of those 119 specific JPEG images, and what do they pertain to?
Most of them deal with just billings, observations by the medical personnel, so that don't necessarily apply to the issue of anxiety, as the court had indicated. I did include certain pages that discuss depression issues, because I believe that they were related to anxiety. And then I've identified 4 or 5 other pages that are not anxiety related that may be relevant to the case. I've described that.
Of those 119 images, how many are being sought? 15? Okay, thank you. State response.
Apparently, these are all just related to a January 23rd, 2018 admission at Advent Health Winter Park. So it appears they're not seeking to introduce any records from other instances that were contained in the records that were first disclosed to the state on September 27th.
You speak of the 81 pages?
Yes, sir.
Thank you.
Nor the new 119 pictures that still not in a PDF form. So of the 15 pages, the first 2 that they list are pages 9 and 10 out of 111. And I believe I've identified them as best I can. However, the Bates stamp from the hospital is over other text, and there is no other Bates stamp. So I had to, I'm guessing that it's pages 9 and 10 out of 111. It appears to just be a health information sharing sheet, like a contract. I don't understand the relevance of those 2 pages. Pages 21, and then they skip 22, 23, 24, and 25 are all part of her initial assessment on 123.18. We don't object to those pages, but for, and I apologize that there's a but for, the fact that at the bottom of page 25 begins her toxicology screening, and that does go into page 26, and they did not indicate that they want to use page 26. However, without page 26, we are going to experience relevancy issues and a 403 objection from the state. And that is because in her toxicology screen, for which she is coming to the treatment to seek treatment for depression symptoms, she is at 165 for ethanol, meaning when converted, it's 0.165 grams per deciliter, over twice the legal limit. It's a central nervous system depressant. We are going to have at least one medical doctor, well, two. The forensic pathologist will testify for the state, and then our expert on battered spouse syndrome, if we get to that point, is also a medical doctor. She's a psychiatrist, not a psychologist. Will tell us that ethanol is a central nervous system depressant. I believe even the psychologists will be able to get that information in. So we are objecting to pages 21 through 25 coming in without page 26.
If I understand your argument, is it a rule of completeness issue?
Yeah, I mean, in the sense that it applies to documents as opposed to statements. I mean, it is an out-of-court statement, so it is a rule of completeness issue, particularly when the symptoms and the complaints of the patient on that particular day were crying and being depressed and showing signs of using a central nervous system depressant. The rest of the talk screen, pages 27 and 28, they did not list. We are not complaining that they are not including that. Page 29 is another page they listed. That's more of a narrative about her visit at January 23rd, 2018. We do not object. Page 43 is just her vital signs. We don't object. Page 44 is more of the initial assessment on this January 23rd, 2018 visit. We do not object, nor do we object to pages 45, 46, or 47.
What are pages 45, 46, and 47, just for my own?
More of this initial assessment
Thank you.
of January 23rd, 2018 was my understanding.
Okay.
Page 48, we are asking again that this be included. Again, I don't believe it's super mysterious why we are going from pages 43, 44, 45, 46, 47, and then skipping page 48 and then going to 49. But we do want page 48 included. On that page includes her height and weight at the time. Page 63.
What's 49? So seemingly that's included.
49 is just some results. Again, it's misleading and doesn't provide full context without what I've described as page 26, because part of the results on page 49 show that she was
Bless you.
tested, shows that she was tested for the presence of ethyl alcohol or ethanol, but it doesn't give the results.
Are the results contained in another page?
Just on page 26, the one I previously described as wanting included.
So not following 49 to 50 or 51 sequentially?
No, because the pages they want from the 40s are 43 through 47, skipping 48, and we're asking for 48 to be included between 47 and 49 to make sure it's relevant and complete. And
But they are also seeking 49, correct?
Yes.
Thank you.
Just they just skipped 48, just like they skipped 26.
Okay.
Page 63. It appears to be repetitive, but we don't have any particular objection. Page 63 of the 111. Page 108 seems to be another part of the initial assessment from January 23rd, 2018. So we don't object to that. So basically we're asking for pages 26 and 48 to be included.
Okay, thank you. The defense did, or I'm sorry, the state did seek a Richardson hearing yesterday in this matter, and based on binding precedent by the 6th District Court of Appeal, Young v. State, 369 Southern 3rd, 1243, regardless of the culling down of the records, the court still is required to conduct a Richardson hearing. As to the issue of whether the defendant's violation was inadvertent or willful, Mr. Owens had advised that these documents were obtained sometime last week. He was unable to provide any specificity. He's going to confer with his office. Mr. Owens or Mr. Beck, are you in a position to advise when these documents were first requested, when they were received, and when they were sent to the state? Specifically, any documents pertaining to Exhibit 2, the Advent Health Winter Park records.
Judge, I did check with my secretary, Margaret, and my understanding is, I didn't know that was going to be a question about when we actually sent it out. I know it was one of my trips down here. I got Sarah Boone to sign a medical release. We sent it to the hospital. It took a couple of weeks, I want to say. We got it last week. We don't know exactly when. We don't timestamp at our office when something is mailed in, and it was mailed in from the hospital to my office. For whatever reason, the records did not get to Shelby, who was handling that issue, until late. It was yesterday or the day before that she was aware that they had not been disclosed. We provided the copy to the state at that time.
So did these records come in batches? Because my understanding, based on the state's representation and their objections, was that the first 81 pages came on September 27th. Those were provided.
Those were separate. Those were records that some of the other lawyers, one of the other lawyers had received, and we sent them on, but the problem was they had notes on them. So we sent that 81, but it wasn't directly from the hospital. So we were trying to get a more complete, unedited copy of the records. That's why we made our request.
Okay, and when was the error identified in time as to when these items were not sent, such that they were provided via USB yesterday?
Whatever date we gave them is when we realized there was an error, that same day.
Okay, my understanding that would have been yesterday morning.
Yes.
Okay. Anything else, sir?
If I may real quickly, based on the invoice that was sent from the advanced building department, it's a separate subcontractor, the request was made on the 27th of September. I suspect they waited until they received confirmation of payment of $135 for receipt of those. So we received those. So it's all been within a couple of weeks, plus we had the hurricane issue last week, and I think there were issues as to the matter being provided for. I did speak with the state yesterday afternoon after I had a chance to look at the records, and advised them essentially what these matters were in relationship to. I was told that they already had those records and we reviewed them. So I don't think there's any prejudice to the state based on our submission.
Okay. Any further argument or positions with regard to the Richardson analysis, Mr. J?
Yes, for the purpose of this hearing, I'd like the stack of documents.
Is that the 119 pages, sir?
No, sir, it's the 81 pages that we got on September 27th, 2024.
Any objection? All right, what was pre-marked A for the purposes of the Richardson hearing will be received without objection as states 1.
Your Honor, there was just a reference that 81 pages were all marked up by the defense. There's no markings. The issue and the confusion that the state attorney's office still has, though, is page 68 of 81 of these original 81 documents.
If you have a cell phone on, they need to be silenced and turned off, please. If you cannot follow the court's instructions, due to the publicity in this case, I will ask for you to be removed. Does everyone understand? Thank you. You may proceed.
And I realize that I've only had a limited amount of time to review the 119 pages that came in yesterday. And again, it's more difficult to review those because it's not in a PDF where I can word search it and do any of the things that are afforded to us with modern technology. It came in as 119 separate JPEGs. They're not in order. So for instance, when I'm trying to look for page 43 of those 111 records out of the 119 pages, it's not in order. And I've done my absolute best to try and see if this page, which is 68.
Yes. And referring to 68 of the 81 that was
Yes,
entered
sir.
as 1, correct?
Yes, sir.
Thank
It
you.
is sub-labeled within these records as page 2 of 14. And it appears to be a part of her visit on January 23rd, 2018. And in the social history provided, it says alcohol use denies, tobacco use denies, and the other part isn't relevant. And I just haven't been able to find that. And so I'm asking for the leeway to continue to try and search for that particular page out of the 119, so that I may ask that out of the doctrine of completeness and fairness, that it be included. I'm just, at this point, I've not been able to find anything in the records that says that, and I'm limited in my abilities to cheat with technology and put it, if there's a 119-page PDF and you make it word searchable, you just put in the magic word, and it helps the attorney greatly. So that's why there's this confusion, and that's part of why I had to raise this issue. Was just at my first glance at those pages yesterday, I knew that something seemed off compared to what was previously provided.
Okay. Any response?
It has a heading, Your Honor. I'm not familiar with that heading in the documents that I was reviewing. I'll look for it again and I'll provide
Okay.
information.
I appreciate y'all working together on that. So here's what we're going to do.
If I may.
Yes.
We had told the state that we would bring in a printed copy, not the PDF, this morning. But Federal Express, which is the block away, for whatever reason, the road was being constructed, so they closed. So we were there at 8 o'clock to get the copy to the state we had promised, but we will bring one at lunch to hand to state.
Okay. Appreciate it. All right. Any other argument with regard to the Richardson issue? Anything further, Mr. Beck? Okay. With regard to, let me conclude the Richardson analysis first. All right. Thank you both for your positions and your arguments. The court has, as a matter of law, the court needs to determine whether the defendant's violation was inadvertent or willful. Court finds that based on the positions provided by the defense that the disclosure was inadvertent, but I do find that the violation had some level of substantiality to it. But due to the state's review and the defense compliance with the court's order yesterday as to culling down to the pages that we've identified, the court finds that the violation had a limited ability on the state's ability to prepare for trial due to the lack of objections to the majority of the documents, with the exception of page 48 and 26, which are sought to be included. For those reasons, I find that the prejudicial effect of the substantial disclosure is limited, and I'm not going to order the defense, not going to prohibit the defense from proceeding forward on moving these items into evidence. However, I do want to address the 403 rule of completeness issue with regard to pages, 26 and 49 as, 26 and 48 as sought by the state. No objection, Mr. Beck. All right, thank you. So the state's request is granted. Pages 26 and 48 will be included in any evidentiary documents that sought to be moved into evidence with regard to this January 23, 2018 incident, as provided in the 119 pages of item 2 of the defendant's Fifth Amended Reciprocal Discovery Exhibit List. I will not foreclose the state regarding page 68 of the 81 pages. If they are able to find that additional document, we can address any argument at that time as to why that should be included. Anything further, state, before we bring in our jury?
Judge, the defense team has indicated to me that they intend on using demonstrative aids during opening statement. The ones that I have seen include jury instructions that may not be given and may not be given in the way that the court gives, and photographs that could be coming into evidence. I identified at least one that I don't recognize as something they sought to be seeking into evidence, perhaps two. So I believe we should have a discussion about each and every one of those. They should each be marked for the record purposes by letter, so that we can refer to them and make a record. I believe it's in the court's discretion, even though I rarely see it exercised in this way in this circuit, to allow the respective parties to refer to actual exhibits during opening statements. I would urge the court not to allow that. They're going to see them soon enough, but particularly with what they are seeking to introduce, given the motion in limine ruling that the court has already issued, that at this point in time, the latest proffer with the defendant's testimony is not amounting to an overt act that will result in a self-defense instruction, that will result in prior instances of violence coming in, that it would be extremely prejudicial, dangerous, and to use Mr. Cacciatore's analogy, very impossible to put that toothpaste back in the tube if we amplify our opening statements, which may or may not come to fruition when we start talking about these past instances and battered spouse syndrome. It would be greatly amplified if they're actually seen exhibits of the defendant's past injuries that she's attributing to the decedent. So I'm asking for us to discuss that.
Response before we go through each photo.
Judge, yeah, the defense is self-defense. Sarah's going to testify that she was defending herself. We believe the court's going to rule we're entitled to put on a case involving self-defense. And under the instruction for justifiable use of non-deadly force and the justifiable use of deadly force,
I'm not discussing the jury instructions at this time.
there are evidence of prior threats, prior events of violence committed under that instruction. Under the self-defense justifiable use.
Here's my concern. Why are we addressing law in opening statement?
Well, I agree with the state attorney. I did pull up a couple of these on the justifiable use of non-deadly force.
That does not answer my question.
I would agree not to use those.
Okay.
The two I'm interested in using and opening is this standard instruction. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering the verdict. You want to read it out?
No, I can see it, sir.
And then the other one is a reasonable doubt is not under possible doubt, speculative, imaginary, or forced doubt is the standard instruction.
What's your position with regard to those two, Mr. J?
Judge, it's opening statements. We should be discussing what we anticipate to come into the trial, and that's going to be enough of a minefield. It really shouldn't be about the law. We'll both have an opportunity to use the actual jury instructions, which we have not decided upon. We will have the opportunity to use that overhead or any means that we want at the end of the trial during our closings to put up what is actually decided to be the law after the case has been presented. So it's our position that we shouldn't be using demonstrative aids with portions of jury instructions. We're going to have that opportunity to argue how the law applies to the facts at the end, and we will have the correct version. And if the court is following the tendency that I've seen in this circuit recently, we may, in fact, read 3/4 of the jury instructions to them before we even begin our closing remarks. I think it's premature and problematic to be doing that at this time, and it's not the role of opening remarks.
Any other response?
Judge, I've been doing this 35 years. I've had these boards. I've used these boards in opening statements. I don't know how many times. I've said that I would waive introducing the one specific to self-defense, but reasonable doubt is an instruction you gave to the jury when we got started. And then this weighing the evidence is a standard jury instruction that applies in every case.
Are those the standard? Is that the language of the standard instruction?
I have not had the opportunity this morning to pull up the Florida Standard Criminal Jury Instructions off the Supreme Court website due to dealing with motions to eliminate, trying to prepare my opening statement, and doing all the things that I should be doing on the eve of openings. But I did notice that I did not believe the reasonable doubt instruction was complete just from memory. And I know that's not the complete weighing the evidence instruction either. It's an entire page of instructions for each of those.
Can I see the reasonable doubt instruction, please? Well, here's the first problem. That's the wrong instruction. Florida Supreme Court revised 3.7 earlier this year. That is not the appropriate definition of reasonable doubt. It is not what was read to the jury during jury selection. 3.7 now reads, proof beyond a reasonable doubt, and it does not mean proof beyond all doubt. A reasonable doubt is not a mere possible, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. That does not track the standard jury instruction. For those reasons, I'm not going to allow it.
Judge, I'll have it redone in arguments.
As long as we're still in the process of working through. The 3.7 instruction speaks for itself. I won't preclude you from using enlargements in closing, but for the purposes of opening, because it doesn't track the 3.7 instruction, I'm not going to allow it.
And this is an excerpt from.
Give me a moment. That seems to be the standard 3.9 instructions, or at least portions of it. Response?
Again, since it's not all of it, it's misleading. It's highlighting something about the law when we're just talking about opening remarks. 6 through 10 are optional. We haven't decided which out of the optional instructions, 6 through 10, we're going to use in this case because we have not heard the evidence yet. So I just think it's inappropriate to be delving into pieces and portions of jury instructions before we get the evidence. What we should be doing is explaining to the jury what we believe the facts are going to show and the inferences that they can draw from them, and argue the law later.
Last bite at the apple, sir.
Judge, they've got to have some guidance to the law, that in many ways, we do it where we give them the law at the very end, and I understand the reason for that, depending on the evidence that comes in, but there's standard instructions that are going to apply throughout. And this is just giving them an idea of what their role is in considering the credibility of witnesses. I think it's appropriate. It's a brief statement of a standard instruction that comes in on every case.
Let me move to the photographs before I address the 3.9 issue.
I think for the record, we should mark them.
Okay. Do you want them marked? You want them marked by Madam Clerk, correct? Okay, so let's approach with that first photograph, please. Madam Clerk, yes.
Exhibit A.
Looks-
Purposes of a demonstrative aid in opening statement. Is a picture of Sarah Boone that was taken by law enforcement on one of the incidents involving arrest. And you can see this letter right here, which we believe is relevant, admissible.
Next photo.
This is B. This is Exhibit B, which is a picture of Sarah Boone on the back porch of the townhouse in question with her two dogs. That's Exhibit C, is a blow-up of the picture of inside the townhouse showing the sliding glass door as well as the staircase that leads to the master bedroom and the That's Exhibit D. Is a picture of the large screen TV with 6 or 7 holes in it from where George Torres hit the TV with a bat right next to their building. That's Exhibit E. Is a blow-up of injuries to Sarah Boone's left arm from George Torres. That's Exhibit F. Is a close-up of the wound to Sarah Boone's leg where George Torres stabbed her with a stick. That's Exhibit G. Is a close-up of Sarah Boone's face that shows where George Torres poked her with a curtain rod. Then Exhibit H is a photograph, close-up of Sarah Boone after she was kicked in the head by George Torres. That's Exhibit I. Is another close-up of Sarah Boone's face after she suffered injuries at the hands of George Torres. All these, I
Thank
believe,
you.
Judge, all these exhibits, except for the first one, A, were in Sarah Boone's phone. The state took custody of the phone. State had the photographs. The state provided the defense in discovery of these photographs. We intend on introducing these photographs. We don't intend on introducing the blow-ups. We intend on introducing the home-size pages of the photographs and then using these as demonstrative aid to show the jury during opening and maybe closing the injuries that Sarah Boone sustained at the hands of George Torres.
Any other further argument with regard to the use of those items pre-marked as A through I in opening statement? Mr. Owens,
Yes, sir, Judge, and I sent you some case law.
when did you send it, sir?
This morning.
I have not received it.
I think you were already on the bench, so we sent it to the clerk and the jail.
Has the state seen a copy of it?
I'm familiar with the case law. I did receive the email. I'm not sure if it indicated who all was copied on it. A separate one, but I'll check.
Is it just these two cases? I've been provided Alsager v. State, 326 Southern 3rd, 656, Florida Supreme Court, 2021. Lowe v. State, 259 Southern 3rd, 23, Florida Supreme Court, 2018. Yes, sir.
Judge, the court has discretion to allow demonstrative aids. If you look at one or both of those, there was a state wanted to introduce a dummy they were using in a homicide case, which the court allowed. Other cases have allowed photographs and demonstrative aids to be used in opening statements. In the Alcaguer case, which is the 2021 case, trial court acted within its discretion in permitting state's use of a map as a demonstrative aid during the guilt phase rebuttal closing argument in a capital murder trial, where evidence visually demonstrated on the map was not without support in the record. That was actually an exhibit that wasn't in the record. The 2018 case, Supreme Court of Florida, again, the trial court acted within its discretion in allowing a demonstrative exhibit. In that case, it was a murder prosecution. Trial court acted within its discretion in allowing the state to use a mannequin in a demonstrative aid in order to show the position of the gun in relation to the victim's body. The mannequin was used to set out the circumstances of the crime and to attempt to establish aggravation. The mannequin was used to demonstrate the location of the gunshot wounds, the angle of the impact against the skin, the incapacitating nature of each gunshot wound. Advising of the trajectories were anatomical, not spatial, and had a small degree of error where only was slight difference between the victim's size and the mannequin's dimensions. There was nothing to suggest the mannequin was altered to resemble the victim. Court allowed, again, the court's discretion. As you know, we're claiming self-defense, and as part of that instruction, we're entitled to allege prior instances of difficulties and prior acts of violence so that the defendant who asserts self-defense, their state of mind is different from the norm. Instructions would read, find that Sarah Boone, who because of prior threats or difficulties with George Torres, had reasonable grounds to believe that she was in danger of imminent use of unlawful force at the hands of George Torres, you may consider this fact in determining whether the actions of Sarah Boone are those of a reasonable person. Goes on to say, you find at the time of the alleged second-degree murder, Sarah Boone knew that George Torres had committed an act or acts of violence. You may consider that fact to determine whether Sarah Boone reasonably believed it was necessary for her to use violence. We have a good faith belief that the exhibits will be introduced into evidence. They're demonstrative aids to aid the jury in understanding the circumstances surrounding that relationship and the actions that Sarah took and the reasonableness of those actions in light of their history.
Thank you. Any response, State?
Yes, sir.
Yes, sir.
Judge, the standard is, it is your discretion, and you will only be reversed if you abuse your discretion in this regard. The state is urging you just flat out, as a matter of principle, to not allow the parties to go into the exhibits during opening statements. They're going to be seeing the actual exhibits in the very, very near future. I mean, we can do this. We can play the videos. We can show gruesome autopsy photographs on the big screen as well during opening statements, but those things are all coming. So we're just asking you first in general, let's not extend the opening statements in that regard any more than necessary. Now, our specific objections are this. With A, which is beneath everything now, but the bloody ear from the prior incident, I believe that is from a body-worn camera, and I think he indicated as much. It was not from her phone. If we get to that point where we know that this piece of evidence is coming in, that would be one thing. But right now, the law of the case is they cannot put on any evidence of prior instances of violence, any reputation evidence regarding the victim, or go into battered spouse syndrome in the evidence until self-defense has been established. And that self-defense must be established by the testimony, and in this particular case, it has to come from the defendant, of an overt act taken by the decedent, which resulted in an imminent threat of great bodily harm or death. And we have had that litigation. We have provided the court the most recent testimony regarding the defendant's most recent statements from the two doctors, and it doesn't exist at this time. So it's one thing for the parties to go into things in opening statements that don't end up coming into evidence. And when the defendant does that, well, under King versus State, the state gets to point out, look, they made these promises in opening statements and they didn't come to fruition. So you need to disregard everything that you heard that was going to happen in trial that didn't. But the problem, particularly for the state side, is we don't get to appeal. So if we go through opening statements and we have the jurors not only exposed to our words about things that may or may not be coming into evidence, but exposed to 1,000 words per picture, if a picture is worth 1,000 words, that amplifies the error. And it's an error the state has no remedy to fix. So we're asking for A, which would absolutely come into evidence. If we get this overt act testimony, which has not occurred yet from the defendant, then certainly A would come in, and some of the other letters. And there's nothing wrong with them blowing it up like that. In fact, the state has it on their exhibit and will be showing it on the screen as well. There's not a lot of dispute over whether that will come in if we meet that standard of an imminent act or overt threat of an imminent act of danger. B, I'm not sure B was on their list of items that they sought to introduce from the phone. We would argue a picture of her with her dogs on her porch doesn't have any relevance. I don't expect that to be coming into trial, so we're objecting on that separate ground. And then returning back to C, D, E, F, G, H, I. State is all aware of those photographs. We are prepared to introduce them ourselves through the digital evidence. There's no hiding those things. If we meet the threshold for this sort of evidence coming in.
Could you identify those for me? I'm trying to keep notes contemporaneously.
Yes. C.
It was C through I inclusive?
Yes.
Thank you.
B is the only one that is not a photograph of prior violence. It's, I don't know, it wasn't on their list of things that they sought to introduce, and I don't know what the relevance would be of her just sitting there on her porch with her dogs. But A and then C through I, judge, absolutely at the end of the trial, great. Blow them up, use them as much as you want. But in this particular case, with the rulings that the court has already made about this, based on the state's motion in limine, it is very dangerous to allow them to do this when we are not expecting it to be admitted into evidence based on the current state of the defendant's testimony.
Thank you.
Thank you.
Mr. Owens, if you could address Exhibit B, was pre-marked as B.
But Judge, you've already ruled that these things come in and open. Remember that? prior
No, what I
rule?
ruled is that you were able to discuss them, address them in opening. Photographs are a totally different kitty.
I said nothing about battered spouse syndrome. I said self-defense. These exhibits come in under self-defense. And arguing these, I've said nothing about matters about, I'm talking about self-defense.
I understand.
And prior difficulties, prior acts of violence is a standard instruction.
But the overt act requirement remains. I mean, we've reviewed Holland and read it multiple times.
In good faith, with discussions with my client, we believe there is going to be evidence of an overt act. That she was facing imminent threat, and she reacted based on that threat.
Understood. Your response to Exhibit B.
So look at B, which one's B?
It's her on the back porch with the 2 dogs.
Judge, not only did he abuse, Jorge Torres abused.
That's not the issue. The issue is that the state represented that it was not part of your exhibit list.
I believe it is a part of the exhibit list. We got this from the state. They sent over a bunch of pictures of flowers or paintings that they want to introduce that they've listed as exhibits. I thought for sure we put this on there, but the relevance of it is not only did he abuse Sarah Boone, Jorge Torres, he abused the dogs. And he would threaten to abuse the dogs to control Sarah Boone.
Okay, thank you.
They're checking, Judge,
All right.
on whether they have.
The court's prepared to rule at this point in time. Thank you both for your presentations and your argument. The court's had the opportunity to what was pre-marked as A through I inclusive. First, with regard to the portion of the 3.9 instruction, purposes of opening statement is to set the table of what the issues are, what the parties believe the facts and evidence will show. It is not a proper time to be discussing law or elements of law, and that is an element of law that will be instructed to the jury at the end of the case. So the court's going to exercise its discretion for those reasons and prohibit you from using the portion of the 3.9 instruction in opening statement. You could talk about this is a job that you're going to have, but I'm not going to allow you to read portions of the instruction for those reasons at this time. With regard to what was pre-marked as A through I, the Holland case is clear. Before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. I understand your good faith belief. I take no position on whether or not you're going to make it or not. That's something that you're going to have to establish. But the concern is that the photographs, some of them are graphic in nature. The lacerations, the sutures, the bruising, facial wounds with bleeding may have such a impact such that the toothpaste cannot be placed back into the tube, assuming that overt act hurdle is not met. The court, again, takes no position on whether or not you're going to be able to meet it because I haven't heard the evidence and testimony. So court's going to exercise its discretion for those reasons. You can talk about it. You can talk about it that she was a victim. You can talk about specific some incidences made it happen, but I'm not going to allow the photographs at this point in time for those reasons, for your utilization of them in opening statements. Any questions or clarifications with regards to the court's ruling? State.
No, Your Honor.
Defense.
No, sir.
All right. Are we prepared to bring in our jury at this time?
Got 2 other issues.
They've been waiting for an hour and 20 minutes, Counselor.
We intend to play the 2-minute suitcase video to the jury in opening statement.
State.
Again, I'm asking you to urge your discretion. They're going to hear it in the next 2 days of court. It's within your discretion whether we're going to start using exhibits during opening statement.
What's the other issue, sir?
I need to approach the bench.
Okay. With regard to the video, I'm not going to allow proposed exhibits to be used in opening statements. It's good for the goose is good for the gander. I'm not going to allow your photographs, I'm not going to allow the state to do anything. You could orally talk about what you believe the evidence and testimony is going to show, but the actual evidence is going to have to be presented here through witnesses or through demonstration and publication after that evidence is admitted. Y'all can approach.
While we approach, can somebody from their team start dismantling?
Please, I would appreciate it. Thank you. Any reason why we cannot bring in our jury at this time? State.
No, sir.
Defense. No, sir. All right, let's stand and bring in our panel. Good morning, y'all may be seated. State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes.
All right, can the parties approach for a moment? All right, members of our jury, good morning. I want to just confirm before we start this morning that you complied with the court's instructions last night to not have any conversations amongst yourselves or anyone else about the persons, places, things, or charge involved in this case. Then you have not conducted any independent investigation regarding those items. You just raise your hands to confer that you complied with the court's instructions. All right, the record will reflect that all jurors have raised their hands. Members of the jury, yesterday I told you that you may happen to see the lawyers in the courtroom or in the courthouse going about their affairs. And again, they're not trying to avoid you or speak to you because they're not allowed to. Did anyone happen to ride an elevator this morning with any of the attorneys, either for the state or for the defense? All right, juror in seat number 3 from my left, first row. Yes, ma'am. Okay, thank you. Can you all approach for a moment? And a juror in seat 4, left to right, first row. Yes, sir. Who did you ride the elevator with? Do you recall who specifically, sir? Mr. Owens. Okay, thank you. All right, thank you both for your honesty. I appreciate that. It's something we talked about earlier this week. That's the one thing that we required and asked of you, is just be open and honest. And I appreciate both of y'all's open and honesty. During the ride in the elevator, was there anything that you saw or observed that it would impacted you or influenced you in any way, to have any impact on you? Juror number 3, left to right, first row. Juror number 4, left to right, first row. Okay, thank you. All right, with that, members of the jury, we're going to proceed with opening statements this morning. Both the state and the defense will have the opportunity to present them. I ask that you listen closely to those statements that they're going to provide. But remember, these are not evidence. This is just the party's belief as to what the facts and the evidence will show in this case. After the conclusion of the opening statements, we'll begin with the state's case in chief through witnesses. With that, Mr. J, you may proceed, sir.
Thank you. Ladies and gentlemen, what the evidence in this case is going to show you is that this defendant zipped Jorge Torres shot in a suitcase. She was able to do this because at the time of his death, he only weighed 103 pounds. And she did this with the malicious intent to punish him. And then she went up to sleep and left him to take his final breaths on this earth alone. How many breaths those were, we don't know. The evidence is going to show that it was at least for about 15 minutes, because there's going to be 2 videos that the defendant herself took of this event. The evidence is going to show Jorge Torres is dead because in this defendant's judgment, he deserved it. And out of a conscious disregard for whether he lived or died, you will see and hear these videos. What I expect you will hear from a video that began at 11:12 p.m., 45 seconds, on February 23rd, 2020, in Orange County, Florida, is a suitcase on the ground, face down, with the zippers facing the floor. You will hear Sarah, the defendant will say, "For everything you've done to me." Sarah, "For everything you've done to me." Sarah, "Fuck you." And then the defendant laughs. Sarah, "Fuck you." And the defendant laughs. Sarah, "Stupid." Sarah, "That's my name. Don't wear it out." Sarah, "I can't fucking breathe, baby. Seriously." "Yeah, that's what you do when you choke me." Sarah, Sarah, Sarah. The defendant laughs again. Sarah, "I can't breathe, babe." She laughs again. "That's on you." Sarah, "I can't breathe." She laughs again. Unintelligible words. And I would submit the evidence is going to show, because of the intoxication from alcohol, is the next thing she says. Sarah, 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 "I can't breathe, baby. That's what I feel like when you cheat on me." Sarah, "Fuck you. I can't fucking breathe, Sarah. You should probably shut the fuck up." Sarah, "Shh," is the last thing you will hear the defendant say to Mr. Torres as he is face down, zipped shut in a suitcase. That, again, began at 11:12:45 and lasts just over 2 minutes. At 11:23 and 3 seconds p.m., there's a second 22-second video, and it's the defendant zooming in on the suitcase. And all you hear during this 22 seconds, after he's been in this suitcase since at least 11:12 p.m., is one more time, Sarah. How did we get to this point where 103-pound Jorge Torres gets put into this suitcase, left to die? Well, the next morning, the defendant wakes up, late morning, perhaps early afternoon, somewhere in this time range, several hours later. And she goes downstairs, and she doesn't see George anywhere, Torres, and eventually realizes, oh my God, he's in the suitcase. The first thing she does after taking him out, and I believe you will hear a description by the defendant saying, took his little legs out. At some point she makes that statement. And tries to resuscitate him. Here's gurgling as she presses down on his 103-pound chest, forcing whatever air was trapped in there out and gurgling. And the next thing she does is she doesn't call 911. She calls Brian Boone. Who's Brian Boone? Brian Boone is her ex-husband. They share a child in common. And this date, February 23rd, normal work day for most people, school day for their child that they share in common. But after they got divorced, the arrangement was every other weekend, no co-parent. And that weekend included Friday, Saturday, Sunday. So it's that free schedule. And then Monday through Tuesdays, their child would be her responsibility. And Wednesdays and Thursdays, their child would be Mr. Brian Boone's responsibility. So February 23rd, 2020 was a Sunday. Now we've led into Monday, 2021. Mr. Boone had been trying actually to contact the defendant several times that morning because he just wanted to confirm she was going to get their child after school every day. And there had been a history of reliability issues on that issue on her part. So you will see in the phone record, he calls her, calls her, and calls her. Then she finally calls him back instead of calling 911. And being the nice co-parent that he is, he comes over. It's a short drive, 10 minutes. And as she's explaining to him what the heck is going on, he peeks in through the front door of her townhouse, which allows you a view all the way to the back sliding glass door. You're going to see that her kitchen is off to the right, but there's a doorway that you can see all the way through. And on the back side of the kitchen in the breakfast area, there's tables and stuff. There's also some blue legs sticking out in view. Brian Boone says, check please. You need to call 911. He doesn't set foot into that townhouse. He does wait outside though, being the good co-parent that he has been. So now, after having first called her ex-husband, after having first waited for Brian Boone to come over, the defendant makes the 911 call. What you will not hear are tears. You will not hear sorrow. You will hear a certain level of concern. My boyfriend and I were playing last night. Put him in a suitcase, and we were playing hide and seek kind of thing. I fell asleep. Found him dead in the suitcase this morning. I don't know what happened. He had blood coming out of his mouth. Don't know if it was an aneurysm. Pulled him out of the suitcase, tried to give him CPR. He was in the suitcase and I fell asleep. He's not awake, he's purple, he's not breathing. There's some instructions about how to do CPR given to her, asking about whether an AED is available to shock his heart. It's too late. He's cold, he's stiff, he's purple. We were playing hide and seek. We were playing hide and seek. This is horrible. This is horrific what happened. Like, what happened? We were playing hide and seek last night and I fell asleep. So she mentions that there was blood coming out of his mouth. And his body, like all bodies in suspicious deaths, was taken to the 9th District Medical Examiner's office in autopsy. What the doctor found was what you would expect after being left in the suitcase, crumpled up in the fetal position. He passed from positional asphyxiation, meaning like you're not going to get full breaths when you're crumpled up like an accordion, and environmental suffocation. You don't have to have a plastic bag over your head, taped shut with a full roll of duct tape to seal it off 100% and be worthy of the vacuum of space to environmentally suffocate. It's close enough if you can't get the oxygen and the CO2 coming in and out of your environment. But she also did notice, yeah, he suffered from blunt force trauma on his torso, in his face, his mouth. She'll use words like contusion. Will help her explain contusions and bruises. She'll use words like hematomas. Will help her understand for you all that that means bleeding under the skin and blood, what you expect from a bruise. That's why they're running through. But he had all this additional trauma. He had trauma on his fingers as well. So now, the sheriff's office, Orange County Fire Rescue show up. defendant interacts with the first patrol officer, you will see and hear that body worn camera. It's more of the same of what we heard on the 911 call. Hide and seek. It was good. I fell asleep. I don't know what happened. A few hours later, the detectives from the homicide unit at the Orange County Sheriff's Office approach her and are ready to interview her after doing some initial things, which includes grabbing her cell phone off of a counter that was found at a suitcase by Mr. Torres, and giving it to one of their digital forensic examiners, who we'll hear from later in the trial. But it's time to give the first interview with the defendant. So they do a first interview with the defendant in one of their unmarked detective patrol cars there on the scene. And the basics of this remain the same, but there's a little more elaboration, as you would expect from trained detectives versus getting the 911 call taken. But the basics of what the defendant tells them is we had wine, we painted, we drew, we did puzzles. The particular wine we had was a Chardonnay from the Woodbridge winery. The bottles, plural, are in the trash. We started about 4 p.m. after Mr. Torres went to the store. Puzzles, art, listening to music, enjoying each other's company. We were literally just enjoying one another's company. The other bottle of wine that was left over from Boone wasn't even half full. So the description she is saying is 1 bottle of wine and plus a fraction of a bottle of wine left over from the night before. Ladies and gentlemen, not all bottles of wine are made the same. Many of us may envision what you would expect at a restaurant. Those are 750 milliliters of that. Bottles of wine that were recovered from the defendant's trash can were 1.5 liters, so the equivalent of 2 standard bottles of wine. A 1.5 liter bottle of wine is 50 ounces. Given that a standard serving of wine is 5 ounces, you can begin to do the math. And there's receipts. The day before, Saturday, February 22nd, 2020, there is a receipt from Publix for a bottle of Woodbridge wine for $9.74. And then Sunday at 12:17 p.m., there is another receipt for $9.74 for a Woodbridge Chardonnay bottle of wine. And then at about 5:30 in the afternoon on February 23rd, again, there is another receipt for the same bottle of wine for the same price. And those 2 bottles of wine were recovered. They're going to be produced to you in evidence, and you will see that they are in fact Magnum bottles of wine. So that's the context that we're dealing with when we hear things like, we only had 1 bottle of wine and we finished what was left in the bottle of wine from before. Well, ladies and gentlemen, there's 2 1.5 liters that apparently were consumed by a 103-pound man and the defendant, who is in the same weight class. Plus, if you believe that the defendant and the decedent would leave leftover wine from any given day, any additional wine that was remaining from the 1.5 liters from Saturday. Ladies and gentlemen, that's a lot of wine. So in that context, we were just having wine, enjoying each other's company. At one point, we play hide and seek. She says she didn't zip it up all the way. There was enough room, and her words again, there was enough room for his little fingers to get out. We were still having a good time and whatever. And basically, Mr. Torres is stressing out about jobs, his ex-wife, about money. And so they're just doing puzzles and doing things to keep his mind off of it. Doing art, playing with the dogs, dancing with the dogs, playing hide and seek. We were always trying to outdo each other where we could find each other the best. When they started playing hide and seek, she went up to the shower and then got tired of hanging out in the shower and came down, and that's when she found him playing around in the suitcase. We both thought it was funny. I'm going to zip you up. Two little fingers could stick out. And she went upstairs thinking, he'll get out, we're going to have sex and go to sleep and call it a day. It was a good day. She insists that they had wine, but we're not drunk. You will be able to assess that for yourselves when you hear the recording she made. No ill will between us last night. Last argument, maybe last week. Don't really argue. We came home, drink, smoke, did art, listened to music, play with the dogs. We drink what we can afford. We used to be able to afford liquor, but now we can only afford wine. And that's how that day ends with the police. She goes and sleeps and stays at her ex-husband's house the night of February 24th. What they are doing, and by they I mean Orange County Sheriff's Office in part, is going to her phone. That's when they discover the two videos that I just described for you. And there's other things in the phone, which I will discuss with you in a little bit. But she's summoned in for another interview, and she sits down and gives another interview on February 25th, now Tuesday. She does describe past instances of violence. You're going to hear about that. She's going to say, Mr. Torres had hit her with a curtain rod about a month ago. Since then, though, like, we've been good. I've been good. She describes that he comes at her all the time. He comes at me. So it's either I flee or I try to go upstairs and go to sleep. That's usually what it is. I don't know if you talk to Brian, her husband, about any of that, but most of the time I flee and I go over there. There's a discussion about why she stays with him, and you'll hear that for yourself. She will say that she doesn't really want to drink. She just takes an occasional drink. She drinks to placate him, Mr. Torres. She says that you're going to see phone videos of Mr. Torres smashing her TV in the past, like a month earlier. You may see that too. But she doesn't get drunk. When she drinks, she likes being non-compos mentis, her words, not mine, having her wits about herself. Then she gets to the hide and seek again and describes that they've played it 3 times before, but had never zipped one another shut in it before. And they were really just running out of places to hide because it's just a townhome. She does not remember, according to her, she does not remember taking any photos or videos of the night's events. At this point, they ask her, well, would you like to see it? And she says, I can't watch this. I flipped him over. I flipped him over, and that's where it was. Guys, this is killing me right now. That's why I flipped it over between the 2 videos. I didn't do anything intentional. Discussion over whether he had enough room to get any of his fingers out from the zipper. My intention was not to leave him there. We both got in there. Both of us were in there. When she went upstairs, my plan was not to, quote, he'll be up here any minute. My plan wasn't to leave him in the suitcase. Why is all this going on? It's the drinking. That's what it is. It's the drinking. I thought he was okay. Guys, that's how we were with each other. Nobody understands our relationship. This whole suitcase thing never happened before, though she described it happening before. I'll never drink alcohol again. She insists that she has no injuries on her, and you don't have to take her word for it because they took photographs of her and there were no injuries on her. She insists over and over that there was no violence that day. It's like, okay, we're in a good place right now. Ask her about saying fuck you to Mr. Torres. Well, that's just being playful and having a good day. Everybody's having a good day. I didn't touch him, nor did he touch me. Her words. What else is found on her phone? There's a conversation between Mr. Torres's brother, and again, nobody knows who's using these phones at the time text messages are sent in these records that you're going to see. But it's indicated that there's a communication between one of the decedent's brothers and the owner of the phone that was taken that belongs to Miss Boone. The text from the brother is, "Yo, my daughter told me what you did, Sarah. I don't want you around any of my daughters or nieces, nephews." And that's Christmas 2019, just under 2 months before this event. She replies, or the person using her device at this time, "Ugh, your quote unquote dad hit me in the face." The next text is, "Hide and seek, I shall." January 13th, there's another heated discussion. She describes it on January 13th in a text to Mo, the brother again. "It's a Torres thing. Boo." Sends a picture. "Keep the fugly creep out too. It's still fugly. Lose." The brother responds, "Please do something with yourself, Sarah. God bless you." The defendant's response, "And bless you and all of you too. I'll get," in all capitals, "rid of him. Then it'll be," in all capitals, "better. Ugh, Torres," referring to Mr. Torres, getting rid of. And that's the case. That's what the evidence is going to show. But we, the state of Florida, and the members of the jury in our journey through this case, are all going to come up to a door that says, "Danger, keep out, stay away, by court order." And that door says, "The defendant's history with the victim is a door we shall not enter without permission and invitation. Halloween in like 13 days. Part of the vampire lore is vampires can't come get you in your own house." Well, I anticipate during this trial, we're going to be invited in to the defendant's past relationship for the previous couple of years with Mr. Torres. And as we come inside this room, at her beckoning, we are going to have things pointed out that she would like us to focus on. And you're going to hear the first night the defendant met the decedent, Mr. Torres, he smashes her phone, punches her. It's the first time in her life she'd ever been punched, I expect the testimony to be. And he made her curl up in a fetal position on her own porch for 4 hours, and she was only able to escape this situation when he fell asleep. I expect that you're going to hear that Mr. Torres is an alcoholic. I expect you may hear his high score on his blood alcohol level was a 342 once when he got treated at the hospital. This is a man who has serious alcohol problems, and I expect you're going to hear about that. Despite that first date, and this is going to tie into some other things that I expect could possibly come in. Despite that first date, despite at that point in time of this first date not having a relationship, emotional ties, and the things that come along with a relationship that make it harder to break off a relationship, it's one thing to have a bad first date. It's another thing to end a 25-year marriage. Despite that first date, there's a second and a third. Now, these dates are at bars, and there's nothing wrong with that. But typically ends up, she's going to tell you, I suspect, or you're going to hear that she said, one way or another. It's one thing or the other. Like I ask a dude for a cigarette, Mr. Torres flips out, and I'm going to pay the price. Just things like that. You're going to hear, potentially see, yes, there were injuries that the defendant is going to attribute to the victim causing her. Black eyes, cuts in the face, perhaps from the curtain rod incident that was mentioned in the police interview, happened about a month before this. Bloody ear, a stab wound in the leg, which is perhaps described as sword fighting, playing around in medical records. But nonetheless, I suspect you're going to hear and see a lot about their past history. And at the end, if this occurs, if this comes in, the state is going to have the opportunity to take the lead of the tour in this room labeled the defendant and the victim's past history. And I'm not going to go into that now. If this all comes to fruit, the blooms on the tree during the trial, we'll discuss it at the end where it's more appropriate. But I'm asking you to not rush to judgment until you hear all of the evidence in the case. And then apply whether or not these past instances have anything to do with what happened on February 23rd. Now, like a home inspector, there are experts to come in and kind of help walk everybody through this room labeled the defendant and the victim's past relationship. I suspect there's a chance you may hear from some experts, psychologists and psychiatrists, about battered spouse syndrome. The state is not challenging in any way that battered spouse syndrome exists. It's well recognized. The experts will tell you all about it. Not disputing that at all. But there's some things that we would hope that you pay attention to during all the testimony, if there is any, about this subject matter. One is that it's not actually a recognized diagnosis in the Bible that they use in mental health called DSM-5-ER. Diagnostic Statistical Manual, version 5. And I think it's text revision, something like that. What it is, and what they describe it as, is kind of a component of post-traumatic stress disorder, PTSD. But because it's not actually in the book, it's like a recipe book. It's like our statute books for lawyers. You go into this book and say you have a particular disorder or diagnosis. It'll say, well, all of us agree that it needs these three elements, like elements of crime. Some of these elements have to be prevalent for a certain amount of time, so on and so forth. You imagine it's a cookbook. Gives you the recipe for a diagnosis. But because it's not in the cookbook, you may get some disagreement about what it means between the experts. It's kind of like grandma's recipe handed down from generation to generation without being right. But what I expect you'll hear is, it's important for people who don't have experience in certain abusive relationships that are violent to understand the control that can be exerted over an intimate partner by the other one, isolation, psychological violence, emotional violence, physical violence, sexual violence, which I suspect will be described for you as well by the defendant, perpetrated on her by the decedent. You will hear about all this. And what it ties into at the end of the day, after we talked about this during jury selection, is if there is a self-defense instruction read to you, this is to help you understand what an objective and reasonable person in the circumstances would do. Because years ago, we've gotten better as a society, but years ago when this was first being researched, the question would be, well, why wouldn't you leave? In battered spouse syndrome, testimony from these experts help explain those things to people. Well, it's not that easy. You got to look at what's going on in the relationship, isolation, control, so on and so forth. And that explains why you wouldn't believe it. Well, now, but turning to the facts of our case, what you're going to decide the facts are is ordinary, objective, reasonable person in those circumstances taking those actions if you get a self-defense instruction as part of that. That's what it's used for. It's not used for explaining the subjective beliefs that one holds. What you will also hear about these things is, just like any other doctor or any expert, a home inspector. If a home inspector's report was based solely on the person who's trying to sell the house, what they say about the house, great shape. I rewired the entire thing. Brand new JVC pipes. This sucker's good to go. I'm privileged. You're not going to take that home inspector's report unless they lift the hood, kick the tires, do all the things that the box on here, Carfax does. You want an expert to get reliable information. An expert's opinion is only as good as the information that he or she relies on. They will say, yeah, you gotta take into account the credibility of the person who's giving you the story. Even if it's the patient, the client that is saying all these things have to be confirmed. You gotta find proper information. You gotta check reliability. Particularly in circumstances that we discussed. So, another thing that they're going to tell you is just because there's a bunch of violent nonsense going on between two intimate partners doesn't mean that spouse syndrome applies. Some people can go home and fight like cats and dogs. And that's just their day, and they get over it. They live their life and find another day. Their cycle just spins like that. So just because you hear about those things, what the experts will tell you, doesn't mean that it necessarily applies. If this testimony comes in, I expect that Dr. Harp will say that it applies to Ms. Boone. But we'll talk to her about what she relied upon to make that conclusion. We'll talk to her about some other things and take that journey together to get there. But at the end of the day, after you hear all of the evidence in this case, particularly straight from the horse's mouth to the video, where you don't have to rely upon the credibility of anything other than your own two eyes and your own two ears, the state submits that you're going to return a guilty verdict for second-degree murder. What the evidence is going to show is that the defendant killed Mr. Torres because she decided he deserved it. Not because the evidence will show an objective, reasonable person in her circumstances needed to. Thank you.
Thank you, Mr. J. Any opening remarks by the defense?
Judge, can we invoke the rule? It has been.
I've already advised the witnesses.
Okay, the rule of sequestration will be invoked. Thank you. You may proceed, sir.
Ladies and gentlemen, good morning. Appreciate y'all being here. I was introduced before. My name is James Owens, and I represent Sarah Boone, along with Tony Henderson and Kevin Beck. Now, this is going to be a several-day trial. Obviously, today, maybe Tuesday, Wednesday, we're not sure, but we're trying to make arrangements for witnesses to fly in, expert witnesses and whatnot, and we'll know more probably end of the day when we Monday, so we can plan. But I know your focus is on this case because you took an oath. Ladies and gentlemen, there is no higher calling than to rely on one. No higher calling than to rely on one. And we're going to ask you again. We find Sarah Boone not guilty because she was justified in the force that she used to defend herself. If that force was reasonable circumstances that existed between Sarah Boone and George Torres. Sarah Boone and George Torres were down and out, as you can be. Their life centered around alcohol. Both of them suffered from, used to be called alcoholism, now it's called alcohol abuse syndrome. And so day to day, they struggle with the use of alcohol. You can imagine that. It affected their jobs. It affected keeping employment. It affected even getting a job. As codependent as you can be towards each other. And you're going to learn with all that was domestic violence. And that George Torres physically abused Sarah Boone. And she suffered from the effects, the psychological effects that one suffers from repeat violence from an intimate partner. They were together over 3 years, and there were several prior incidences of violence. We've got the photographs. There were incidences where police were called who took photographs. So you're going to be able to see the evidence. And we believe the court will instruct you at the end when you're considering self-defense, which we call justifiable use of non-deadly force or justifiable use of deadly force, that you can consider the prior acts, the history of violence, the prior difficulties that the parties had. In considering her set of circumstances that she was faced with in making the decision to use reasonable force under the circumstances. And the most important thing I can tell you here today is keep an open mind. There's two sides to every story. You're going to hear the state's side, them attempting to paint her a certain way, as they've done here today in opening statement. And then you're going to hear another side. And you're going to have to weigh that, all the evidence, the credibility of the witnesses, the photographs, the videotapes, and come to a conclusion. Now let's talk about this day, February 23rd of 2020, the date of this event. This case has been pending for some time. Here we are, October of 2024. I think the evidence is going to show that they had purchased some wine the day before, but they hadn't finished all of that. So it was in the refrigerator. Many times that's how they start their day. At some point, you're going to see a video from Publix, from where they live. I believe it's Winter Park. But Publix was not too far from their apartment complex. And they took their car, they drove over there. So you're going to see a videotape from Publix of them both going in the store about noon, and they come out with one of those larger bottles of the wine, and then of course there's a receipt, and the bottles are in the garbage can. Of course, there obviously is an attraction between the two, and as everybody knows, couples can have great times where things click, everybody gets along, and then we can have episodes of disagreement. And how are those resolved? Really, is what this is about. How are disagreements resolved? But George was very jealous of Sarah. And you're going to hear the testimony about that. And that he cannot, in certain situations, he can be very charming. But when his level of intoxication gets to a certain level, is when he gets sad, moody, and a lot of times eventually it involved forcible sex with Sarah Boone or actual physical violence against her. They bought the wine. It's a simple life. They don't have much money, but they both like art. They did that for a while. They both like puzzles. They did that for a while. Well, about 5 or so, the wine bottle was gone. And George had said, I want to go get some cigarettes. So there's a convenience store right close by their apartment complex. And Sarah thought he was just going to walk over there and get cigarettes and come back. But no, what he did was he got her keys, he got her debit card, and he went over to Publix and he got another bottle. And I think that was about 5:30, something like that. And again, there'll be the Publix video showing him going in, going out, and there'll be a receipt for the purchase of that bottle, and then they'll keep that bottle. Will be in the garbage can along with the other bottle. Well, when he comes in with the second bottle, Sarah knows. This is not good. She knows this means he's going to get to another level of intoxication. So Sarah's concerned. So she attempts to placate him, keep him busy, keep him in a good mood. They drink that bottle, or she drinks as well. And at some point, they're intoxicated at a high level. As some people do when they're drunk, they get silly. And they decide to play a game of hide and seek. She goes upstairs, their bedroom's upstairs, to the shower and waits for a period of time. And he doesn't come to her. At some point, she gets cold, she gets tired. She wants to go see, well, maybe we got it mixed up. Where is he? So she goes downstairs, and they had gotten a suitcase down a week or so ago. It's an old suitcase that they were going to donate to Helping Hands or Goodwill or somebody, and they were putting some items in there. And it's a broken down suitcase. It's a large suitcase. They both weigh about 100 pounds. And they don't eat good. Malnourished to a large degree. But the pull handle is broken off. And they've attached a little paper clip that's got the rubber around it. And that's how they hold it back and forth. Well, she comes down the steps. She sees him getting in and settling in the suitcase. So she walks over there, and they see each other. They smile and laugh, and she zips him up. And she zips him up, and they laugh for a while. And they carry on. She sits on the couch. And at some point, he says, I can't breathe. Now, his face is facing the zipper, and she's got 2 or 3 inches that she's opened it. And she doesn't know. They're intoxicated. She doesn't know whether he's just saying that to try to get her to get him out or what. But he's a captive audience. Physically, they're the same size, but he's much stronger than her. If they got in a fist fight, he would win 100 times out of 100. But she's got him now. He claims he can't get out. He has to sit and listen. It's a unique form of physical restraint. And so she lets him have it. Says things she shouldn't say. You'll see the video. It's about 2 minutes long. She videotapes it. She sits on the couch and turns her phone on and videotapes it for about 2 minutes. There's another video that's approximately 11 minutes later. The first video, the suitcase is flipped upside down. The zippers are off. 11 minutes later, Sarah has flipped it right side up. Again, open for him to get out. And it's only 22 seconds. And you hear George say, Sarah. And that's it. Now, the key to the case is that 11 minutes. And what happened during that 11 minutes. Okay? That is the key to this case. Sarah Boone will take the stand. She will explain what happened. She will explain why it happened. The evidence will show that she was justified in the action she took to prevent an attack from Jorge Torres, which the law acknowledges that every one of us has a right to invoke, the right of self-defense. You can hear from the medical examiner. She is going to tell you about some bruising on Jorge Torres. Of course, he was in the suitcase a while, deceased, we believe. And that changes things a little bit, as the medical examiner will explain, but there's some bruising. Sarah's going to explain that to you. Why that happened. What were the circumstances surrounding that? Involving the bat. Her son comes and stays with them from time to time. He has his own room. He has several of his things there. And there's a bat downstairs. The same bat that Jorge Torres used, and there's a video where George is threatening Sarah. And he's swinging the bat at the TV about as hard as he can. And he does it about 6 or 7 times. You'll see it. Sarah's recording it. And it's during an argument. And he's trying to intimidate. Sarah loved you. You know, you're going to hear why women don't leave. Why women don't leave. And you're going to hear about Sarah Boone and her struggles, her mental health struggles. Sarah had no intent to kill him. The prosecutor mentioned she wanted him to die. Farthest from the truth. She loved the man. She hated the abuse. She couldn't leave him. She tried. She tried kicking him out 6 or 7 times. He kept coming back. She changed the locks. He kept coming back. She didn't have the family. She didn't have the support. She was weak, vulnerable. You're gonna hear it all. You gotta take that all into account to try to understand what happened and the circumstances surrounding this tumultuous relationship. Now, you're going to find that Sarah's not perfect. And, you know, as many of us do when we drink too much, you know, you sleep in. She slept in. 11, 12, 1, somewhere around there. She moseys downstairs looking for George. She thought he was on the computer looking for a job. She looked outside, maybe he's out smoking a cigarette, and she sees the suitcase. She unzips it. She gets him out. He's purple. She tries her best to do some CPR. She freaks out. The only family she's got is her ex-husband, really. She relies on him. As the prosecutor said, a lot of times she'll flee to her ex-husband's house. And her son is at Lucas. It's the only thing she knows to do. She was kind of a sheltered daughter when she was younger. She's smart, but she's not worldly. She calls Brian. What do I do? He said, I'm coming over. Please come over. He's about 5 minutes away. And she calls him again within a couple of minutes. Yeah, I'm on the way. He gets there. He walks in the foyer and sees his legs. He said, call 911. She calls 911 within a minute, two. Detective Rodriguez arrives. You know, they got the body cam now, so it's recorded. So you're going to hear Sarah talking. But Sarah's freaking out. Sarah's thinking, and I'm somehow responsible. Eventually, she gives a statement to law enforcement. She gives one to Detective or Deputy Rodriguez. Of course, she's not the homicide investigator. She's just responding. She's the first responder. And, you know, they know what to do. They try to assess the situation. They start putting the tape out. And then they call for the homicide investigators to come, which takes a little time. So she gets a statement from Sarah. Eventually, the homicide detectives get a statement from Sarah and one of the unmarked squad cars. And it's recorded. They hear that. And then the next day, they take Sarah's phone. Sarah gives them the phone, signs the consent to take the phone, take it to, they have a phone extraction people at the sheriff's department where they can take it and take out all the data, all your phone calls, text messages, photographs, videos, all that. And they find these two videos. Sarah is not aware, she doesn't remember making the video, if you can imagine. She gives them the phone. Well, she makes no attempts to do anything other than, here's the phone. So they tell her, you're going to get your phone back tomorrow. We'll bring it back to you tomorrow. Well, they end up having a conversation with the female detective, homicide detective, Hobson is her name, Chelsea Hobson. And they end up, Deputy Hobson was pregnant. Or Detective Hobson was pregnant. Said, end up, hey, we're not going to bring your phone. I'm not feeling good. Pregnant. Can you come to the sheriff's department? Which Sarah Boone was to tell you that was what I was going. That's what they told me I was going to the sheriff's department for. Well, instead it was an interrogation. and they were going to arrest her. They made their mind up on it. And they were going to confront her and try to get her to confess based on the two videotapes. And so there's approximately a 2-hour interrogation that was on the 25th in the afternoon. When she got there to get her phone, they said, well, we got to come up here. We need to talk to you. And they got her in the room. It's a small room, but it's being videotaped and audio taped. And it goes on for about 2 hours of them trying to get a confession to murder. And it doesn't happen. But Sarah lies. She's scared. She can tell they're trying to pin her on this, that this was some kind of intentional act, and it was not. So she lies. She's not a lawyer. She doesn't know about self-defense. She doesn't understand she has a lawful right to defend herself. She doesn't understand that she's justified in using the force that she used. She doesn't. I wasn't there to advise her. No lawyer was there. So she lied. And you're going to hear that. So you're going to have to balance that versus her taking the stand and testifying before you. And we simply ask that you look for the evidence of cooperation of her testimony. It's going to be later, probably next week. The judges will tell you and read an instruction on evaluating a witness's credibility. And they'll talk about corroborative evidence, other evidence that's consistent with the testimony that Sarah Boone gave. So you're going to have to weigh that in her testimony. Now, self-defense, we talked about it in jury selection, usually a gun, some deadly weapon. The suitcase in this case was a physical restraint or a blocking of an attack, but it was unconventional. Self-defense nonetheless. Now, as I said, the struggles that occurred, many of them involved the police. So you're going to actually hear from some of the police officers. Maybe some body cam footage. You're going to see some photographs that they took of the injuries to Sarah Boone. And some of the videos you may see of her in a very happy, joyful type of thing. Well, number one, she's intoxicated. Number two, she's safe. Police are there. So her attitude is not one of distress. We're here today, full packed courtroom. Judge Green's here, but you're the most important people. Because you've got to decide this case honestly, fairly, and according to the law. And we talked about the two biggest principles from the Constitution that apply. In this case, and in every case in which a citizen like Sarah Boone is brought into a courtroom and accused of a crime. The first is, you as a juror must presume or believe that Sarah is innocent. And that belief stays with you throughout the entire trial. Because of that, she doesn't have to prove anything. That's why the state went first in jury selection. That's why the state went first today. That's why the state will go first putting on their case. They have the burden of proof, and it's the highest burden we recognize in any type of litigation in this country. Proof beyond and to the exclusion of every reasonable doubt. You are going to have doubts about this case. But the most important thing is not to rush to judgment, to keep an open mind and understand there's two sides to this case. There's their side and there's our side. So you can't form any fixed opinions early on. That's hard to do, as Mr. Henderson said in opening or in jury selection. That's extremely hard to do. Now you're going to hear some testimony. There's been mention of experts. Battered women's experiences affect her perception of imminent danger. Battered women's experiences affect her perception of imminent danger. Victims of repeat violence may fear death in a situation others would not. After hearing both sides of this case, we're confident you're going to have a reasonable doubt. And we're going to ask you to follow the law and do justice in this case. And find Sarah Boone not guilty, because it's the right thing to do. Thank you.
Thank you, sir. Can the parties approach for a moment? State, you may call your first witness.
State will call Juan Torres.
Mr. Torres, raise your right hand, please. Please do you swear or affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Sir, good morning. You could be seated. And once seated, if you'd state and spell your name for the record for us, please.
Juan Torres, Juantorres.
Thank you, sir. You may inquire, Mr. Cacciatore.
Good morning, sir.
Good morning.
Can you tell us how it is that you know George Torres?
He's my older brother.
And how many siblings do you have?
Six or seven.
And how long has your family resided here in the Central Florida area?
20 plus years.
And before residing in the Central Florida area, were you guys in Philadelphia, Pennsylvania?
Yes, sir. In Massachusetts.
Your brother, how often, your brother George, that is, how often would you talk with him?
Often we talk, say, on a weekly basis.
And how far away did you live from George?
About 5-10 minutes, pretty close.
Would you see him pretty often?
I would try not to go over there too much.
Who was George living with at the time that he passed away?
Wait, Sarah?
And without getting into many details, what was your relationship like with Sarah?
We wouldn't really have a relationship.
Would it be fair to say you didn't get along with her?
Yes.
Back on February 23rd, 2020, did you have an occasion to talk to your brother on that day?
Yes, sir.
And when you spoke with your brother on that day, did you FaceTime with him or did you speak with him over the phone?
We talked on the phone.
Was that phone to your ear or was that phone?
It was on speaker.
And who was present?
My wife and my 2 kids.
And without telling us anything that George may have said to you, can you tell us what the topic of that conversation was?
We were just talking like we normally did. He just calling me to check on me, basically.
Now, in the background of that conversation on the evening of February 23rd, 2020, what did you hear?
Sarah's in the background yelling.
And you recognized her voice?
Yes.
What was she yelling about?
Something about choking or how he choked her. I really don't. That was it.
About how long was this conversation that you had?
Maybe 10 minutes, I think it was.
How did the conversation end?
Because she was yelling in the background, so that was it. We just,
Did she sound upset?
she sounded upset.
Did you talk to your brother after that conversation?
No, that was the last conversation I had.
Have you ever spoken to Sarah since that conversation?
No.
I have no further questions.
Any cross-examination?
Good morning, sir.
Good morning.
In the beginning, when you started, it was hard for me to hear, but I know you were talking about other siblings, other family members that you had here. Could you repeat that for me, please?
Here in Orlando, I have one sister and 3 brothers.
Sister and 3 brothers?
Yes, sir.
Okay. Now, did your brother George Torres, did he ever stay with you at any time?
No.
Would he ever live with you or any of, I mean, not you, but any of your other siblings?
No.
All right, sir, let's go back to this phone call that you were talking about that was on February 23rd of 2020. And that phone call was approximately 7:30. Is that correct?
Yes, sir.
And who called who?
He called me.
And then y'all were talking. Is that correct?
Sir,
And when he called you, did you notice anything about his speech or his voice?
no, he was fine.
Sounded normal?
Yes, sir.
Okay. So he wasn't slurring his words or anything like that?
No.
By the way he talked or what he talked to you about, could you tell at that time if he had been consuming alcohol?
No, because I knew when he would drink.
Okay. So in your opinion, at that time, based on what you heard and what he was talking about, you do not believe he had been drinking alcohol?
No.
Now, you said you heard Sarah.
Yes, sir.
Is that correct? How did you know it was Sarah?
I can tell her voice.
You recognized her voice, so you could hear her. Is that correct?
Yes.
All right. And you've heard Sarah speak before that time. Is that correct?
Yes.
And you've heard her speak on the phone before that time. Is that correct?
Yes.
And you said that Sarah was yelling. Is that correct, sir?
Yes.
And she was yelling about, he's choking me. Or tell him about choking me.
Yes.
Okay. During that conversation, and you heard her say that, did you ask your brother, what is she talking about?
No, I did not.
Did that statement at that time, did that statement surprise you?
Not really.
You've heard it before?
No.
Based on Sarah's voice that you've heard, was it any indication to you that she had been drinking?
No.
No? Sir, at some point, your brother said he had to go. Is that correct?
Yes, sir.
And did he hang up on the conversation?
Yes.
And did he say bye and you say bye?
Yes.
Thank you, sir. I don't have, if I can. confirm.
You may, sir.
Sir, other than siblings, your mother and father, do they live in this area?
Yes.
Were there times that George would stay with them?
Yes, sir.
Thank you, sir. No further questions.
Any redirect examination?
No, Your Honor.
Can this witness be released?
Yes, Your Honor.
Defense?
Actually, we'll keep him subject to recall, Your Honor.
Okay.
I would agree with that.
All right, sir. You're released subject to recall by either party. Thank you.
State would call Devin Jamro.
case, do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Sir, good morning. You could take a seat and please state and spell your name for the record.
My name is Devin Jamro. That's DevinJamro.
Thank you. You may inquire, sir.
Sir, who do you work for?
I work for Public Supermarkets.
And what is your position with public supermarkets?
I am the assistant store manager.
And at what location?
Currently, the Castleberry location.
Were you at the location on Goldenrod and University Boulevard back in February of 2020?
Yes, I was.
Your Honor, may I approach the witness which has been previously marked for identification as states D and been shown to defense?
D is in Delta?
D is in Delta.
Yes, you may.
Sir, I'm showing you it's been marked for identification as states D. Could you use these scissors and open this and look at the contents of this package to yourself?
Sure.
Sir, do you recognize those items?
I do. Yes.
And tell us, what are these items?
These are Publix receipts.
Are these receipts evidence of transactions at Publix? Are they made at or near the time of each transaction?
They are absolutely made at the time of the transaction.
And is it in the normal course of business that Publix keeps these receipts?
Yes.
And these fairly and accurately appear to be the receipts from your Publix store?
Yep.
Your Honor, at this time, I'd like to move what's previously been marked for identification as states D into evidence.
Any objections?
No objection?
What was pre-marked as states D will be received into evidence without objection as states 1.
Your Honor, may I approach the witness who's been previously marked for identification as states J and shown to defense?
You may.
Sir, I'm showing you it's been marked for identification as states J. Can you take a look at that disc?
Yes.
Do you see your initials on that disc?
I do.
Did you have an opportunity to look at that disc prior to coming to court this morning?
I did. Yes.
And tell us, what is that disc?
This is CCTV footage burned from the camera system at the location.
And at Publix, is it the regular practice of Publix to utilize surveillance cameras?
Yes.
And in the normal course of business, are the videos from those surveillance cameras kept?
Yes.
And are these the cameras taken from February 23rd, 2020? And I believe there's 2 video clips included, one at 12:17 p.m. and another at approximately 5:39 p.m.
Yes.
And they fairly and accurately represent the surveillance video that was submitted from Publix to law enforcement in this case.
They do. Yes.
Your Honor, at this time, I'd like to move what's previously been marked for identification as states J into evidence.
Any objections?
No objection?
What was pre-marked as States J will be received into evidence without objection as States 2.
And I have no further questions for this witness.
Any cross-examination?
Yes.
Can this witness be released?
Yes.
Thank you, sir. You're released.
Thank you.
Have a great day. State, you may call your next witness.
State will call Joan Williams.
Raise your right hand to the wall, please. Do you swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Ma'am, good morning. Could you state and spell your name for the record for us?
Okay, Joan, Joan Williams, Williams.
Thank you, ma'am. Counselor, you may inquire.
Good morning, ma'am.
Good morning.
Can you tell us what it is that you do for a living?
I'm a 911 call taker at Orange County Sheriff's Office,
And how long have you held that position?
24 years.
And tell us, what are your duties as a 911 call taker?
I answer phones for an emergency, non-emergency, medical. We try to transfer to the medical side of the business.
And is it the regular practice of Orange County to record 911 calls?
All lines are recorded.
And is it the regular practice of Orange County to keep records of each of those 911 calls?
Yes.
And those records are made at or near the time of each call, correct?
Yes.
Your Honor, may I approach the witness which has been previously marked for identification as states L and been shown to defense?
You may.
Ma'am, I'm showing you what's been previously marked for identification as states L. Do you recognize this disc?
Yes. My initials.
Did you have an opportunity to review this disc prior to coming to court this morning?
Yes.
And those are your initials on the disc?
Yes.
And does this disc, does it fairly and accurately represent the 911 call that you took in this case on February 24th, 2020 at 12:59 hours?
Yes.
Your Honor, at this time, I'd like to move what's previously been marked for identification as states L into evidence.
Any objections?
No objection.
It was pre-marked as States L will be received with no objection as States 3.
Your Honor, I have no further questions.
Any cross-examination?
No, sir.
Can this witness be released?
Yes, Your Honor.
Thank you, ma'am. Can the parties approach momentarily? State, you may call your next witness.
State will call Vincent Battaglia.
Sir, you may be seated. After you're seated, if you can state and spell your name for the record for us.
Vincent Battaglia, Vincent Battaglia.
Thank you. Sir, you may inquire.
Good morning, sir.
Morning.
Can you tell us what it is you do for a living?
Right now I work for an auto parts company,
And where do you live?
New Jersey.
Back on February of 2020, where were you living at that time?
I was living at the Tealwood Apartments in Winter Park, Florida.
And what were you doing at that time when you were living at Tealwood?
I was enrolled in Full Sail University. I was in school.
When you were living at Tealwood, did you have any roommates?
Yeah, I had one roommate, Brandon. Yeah, that was it. Him.
That's Brandon Moats.
Yes.
Did you have neighbors?
Yeah.
Were you neighbors with Sarah Boone and George Torres?
Yes.
And approximately how long were you neighbors with them?
About a year, a little over a year. I moved there in January 2019.
And during the course of that year that you were neighbors with them, did you have occasion to interact with them at times?
Yeah.
In fact, did you ever go over to their home?
Yeah, like a couple times, yeah.
And I believe you tuned a guitar for a child there at the house?
Yeah.
This Tealwood apartment complex, how would you describe the walls that separated your units?
Thin, like very thin walls.
And with those walls being so thin, would you ever have occasion to hear arguing and yelling coming from Sarah Boone and George Torres's apartment?
Yeah.
How often would you hear this?
Almost daily.
Did Sarah Boone ever approach you about the things that you heard coming from their apartment?
Yes.
And where were you when she approached you?
I was smoking a cigarette on my back patio.
And approximately what time
It was
was this?
pretty late. I can't remember the exact time, but it was definitely anywhere between like midnight to 2 a.m., like right around there.
And do you remember how much before the date when the police called that this occurred?
A few months, like it probably 4 to 5 months before that.
So 4 or 5 months before February
Of
of
2020.
2020.
Yeah.
And when she approached you on this late evening / early morning on that day, what did she tell you?
Pretty much just kind of like if I do hear anything like through the walls or whatever is out back, just kind of keep my mouth shut. Like don't really speak about it or anything like that or say anything to anyone. And I just was like, okay.
Did she make any motions with her hands?
Yeah, like just kind of like, finger over the lips, like kind of shh, like keep it hush, like that kind of thing.
So she told you not to report anything you may have heard about arguments or yelling or fighting, anything going on over there?
Yeah.
Do you recall the evening of February 23rd, 2020?
I do, yeah.
And what about that evening sticks out to you?
That sticks out to me from that night was literally just there was a very, very loud noise that I heard that was loud and powerful enough to shake my bedroom wall. And I remember that because I was sitting on my bed on FaceTime with my girlfriend at the time, and I literally felt the wall shake and it stopped me mid-conversation. And she even asked me through the computer, like, what was that? And I was like, I have no idea.
Did you hear any yelling coming from their apartment on that night?
Before that, yeah, like it was just arguing kind of stuff.
What was the last thing you heard?
The last thing I heard was like the loud noise and just a little bit of shuffling, and that was kind of it. It just kind of went silent after that.
Could you hear anything that was being said?
Not clearly, and it was never really anything clear. It was just like you could hear arguing back and forth, just kind of like an I hate you, like it's whatever it is, whatever the argument was about kind of thing. At the time, that's really all it was, but it was never really clear enough to hear like the full argument. And honestly, I never really paid attention too much to it. If I heard it, I kind of stepped into my living room to be further away from it.
Did you hear both the defendant's voice and also George Torres's voice?
Yeah, all the time. It was like a back and forth.
So other than the statements and the phrases of I hate you, you weren't able to discern the contents of this argument.
No.
What was the last sound you heard?
The last sound that I heard was like the loud banging noise that it was like a very odd sounding noise that I've never heard before this day, but it very much sounded like it was where my bed was positioned. It was kind of towards the back of the apartment, and it almost sounded like it was coming towards me, but like on the side of me, then it was just like a loud rumbling noise. That literally sounded like it was kind of far away from me, and then it like ended up like almost next to me. And like I said, the walls are thin, so like it's very easy to hear like through the walls, and not even just sideways. Like I hear my upstairs neighbor, like all around, very thin walls.
Now, was your bedroom, where was it located in your apartment?
The back of the apartment, so it was like there's like a little kick out next to my patio, and that's like that was my bedroom back there, like along the grass back there.
On the first floor?
On the first floor, yeah.
I have no further questions.
Any cross-examination?
Mr. Taglib, good morning.
Good morning.
Now, you said that you lived there next to Sarah Boone and George Torres for about a year.
Yes, sir.
Are you aware that the police were called to their residence
Like,
while you were there for the year? Are you aware of any incident in which the police were called to their residence?
I had never seen anybody there, but I had had other neighbors in the complex tell me that it has been on multiple occasions. So that's why.
Just instead of what somebody else told you,
Yeah.
just what you would observe. Did you ever, the year that you were there living next to them?
Yeah.
Were you ever aware that the police were called to their residence?
No, the times that I was home, I never saw any police at the apartment there.
And did you work odd hours or you went?
Yeah, and with my schooling and stuff too, I used to have class at like 1 o'clock in the morning. So all the time I was at random moments, like just not home throughout the day and night and stuff like that. So yeah.
Do you have an opinion as to whether or not, based on your interaction with Sarah Boone?
I'm going to object.
Let me finish the question first, please.
Do you know from your experience with Sarah Boone and your experience with George Torres that they drank alcohol?
Yeah.
Hang on.
I'll withdraw to that question.
Okay, thank you.
Yes.
Are you aware that they both consumed alcohol to excess?
Yes.
Thank you. Hold on.
Yes, sir, of course.
Well, Vincent, I think you had testified, you may have given a statement to law enforcement,
Yes, it was one of the detectives.
a recorded statement.
Yes, I can't remember his name, but yes.
Okay, and I think it was on February 23rd of 2020.
Yeah, right around that time, yeah.
I believe you had said that,
I'm going to object this to improper impeachment.
Approach. Objection's overruled for now.
sir, would it be fair to say on that date you got home around 7 p.m.?
7 p.m.
Yes.
Which day was this?
Sunday, February 23rd, 2020.
No, that day I actually got home from work probably around 1 or 2 o'clock or so.
In the morning?
No, in the afternoon, because I went to work that morning at around 5 a.m.
And you said that you heard the normal yelling and arguing at about that time when you got home?
No, it was it was around that time, but it was really around like 10 o'clock, 10:30 is when like the arguing I could really hear clearly. It was like around 10:30 at night.
Okay. Thank you. Thank you.
Any redirect?
Just very briefly.
Yes, sir.
So on cross-examination, you were asked about the arguing you heard, and I believe your testimony was that it was pretty intense around 10:30.
Yeah.
Approximately what time was it that you heard this loud crashing thump sound that you described?
Little after that.
Overruled.
It was a little after that arguing and stuff. It was probably around 11:15, probably 30, 45 minutes after like the arguing I could hear started.
No other questions?
Can this witness be released?
Yes, Your Honor.
Not subject to recall.
We would like him subject to recall. You've got his number.
Okay.
Your Honor, may we approach?
Yes. All right, sir, you are released, not subject to recall. Have a great day. Thank you.
The state would call Brandon Moats.
Bless you.
Raise your right hand, please. Swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Thank you, sir. You can be seated. State and spell your name for the record for us.
Yeah, my name is Brandon Moats, BRANDON MOATS.
Thank you. Mr. Cacciatore, you may inquire.
Good afternoon, sir.
Good afternoon.
Can you tell us how it is that you knew Sarah Boone?
I moved into the apartment next door to her when I was in college.
And so when was that you were in college?
I would have moved down here in 2019 and would have been there until like 2021.
So she was your neighbor at Tealwood Apartments, is that correct?
Yeah, it would have been Tealwood back then, yeah.
And did you have any roommates back then?
Yes, I was rooming with Vincent Battaglia.
And during that time, what were you doing? Yeah,
Like,
as far as work and school? And
I was just going to school. During the time of this, yeah, I would have just been going to school. I don't think I would have had my job yet. I was just a student.
Did you have much interaction with the defendant or with Jorge Torres in this case?
Honestly, I avoided them as much as possible usually.
The apartment where you lived, tell us, how would you describe the walls that separated your units?
Yeah, I remember that my bedroom was like the front facing bedroom and our walls shared a wall with where their staircase was. So like the way the apartments were laid out, we had a 1-story apartment, they had a 2-story apartment. So they had a staircase running right next to the walls next to like our bedrooms.
Would you ever have occasion to hear arguing and yelling going on inside of the defendant's apartment?
Yes, the walls were pretty thin. So if people were yelling, you could definitely hear it.
And how often would you hear arguments or disagreements going on over there?
When I first moved in, it was at least like once a week, to the point that I started tuning them out. Like I got good enough at just like not listening to them. They argued very, very often.
Do you recall the evening of February 23rd, 2020?
Yes, sir.
And on that evening, could you hear arguing going on in their unit?
Not late into the evening, earlier into the evening, probably like 7, 8 o'clock that evening, probably like earlier on, I could hear arguing.
And where were you inside of your apartment?
I would have been in my bedroom pretty much all night.
And your bedroom, just so that we can paint the picture, where would that would have been, on the first floor or the second floor?
We had a first floor apartment.
Okay, so all the units were, or all the bedrooms were on the first floor.
Yeah, like I was saying before, we had a 1-story apartment, and then they next door had like a 2-story townhouse. So we only had the 1 floor.
Understood. And at a certain point in the evening, did you hear a loud crashing sound?
Yeah, probably around 10:30, 11 o'clock that evening.
And can you describe that sound for us in more detail?
I mean, yeah, at literally, like I said, at like 10:30, 11 o'clock, it's the way their staircase was set up. I could, my bedroom, the top of their staircase would have been like above my ceiling, and it ends next to where like my roommate's apartment was. So I could hear something start above me super loud and then fall away from me like it was falling down the stairs.
Did this affect the walls that were between your 2 apartments?
Oh yeah, me and my roommate, I remember me and my roommate talking the next day about like we could literally, like, it shook both of our rooms.
Did you ever have occasion to talk with the defendant about what happened?
I never saw her after that. She would have, I never saw her after that happened.
No further questions.
Any cross-examination?
Good afternoon, sir.
Good afternoon.
Sir, you were asked by the state if you ever had any interactions with Sarah Boone or George Torres? Is that correct?
Yes, sir.
And I think you said you tried to avoid them.
Yeah. I don't like drunk people, and they were drunk a lot, so I did not interact with them.
Do you remember this interaction with Sarah Boone in 2009 when you woke up and witnessed Sarah
I
sleep?
would have been 9 years old in 2009.
I'm sorry, 2019. Good catch. In 2019, when you woke up and witnessed Sarah sleeping on the concrete patio.
Oh, this may have been a slight misconception in how I said this. I never woke up and saw her sitting on the patio myself. That I would have seen her on the patio eventually, but it's not like I woke up and went back and saw her on the patio. This was my roommate relaying the story that she had fallen asleep on the back patio, and then I saw her.
So you did not witness that yourself, or did you see her?
I saw her asleep on the back patio. I was just clearing up the sequence of events there.
Okay, thank you. Another time, do you recall our interaction with Miss Boone when you were coming home from school and she was trying to talk to you and she seemed paranoid and rambling?
Yeah, I had gotten locked out of my apartment, so I was waiting on the steps to. I was waiting on the steps outside of my apartment for my roommate to get home. So she came up and started talking to me. I don't really remember too many details of what she was saying, because I didn't want to talk to her. But yeah.
Okay. Do you remember saying that you believe Sarah was avoiding going into her apartment?
That's definitely the vibe. I don't remember what she was saying, but the vibe she was giving off was that she didn't want to go home.
Now, I believe, and I just want to make sure that I heard you. You said that the first arguments, other than the boom, which was like 10 something, initially it was around the 7 p.m. You heard arguing.
It would have, yeah, because it would have been. I remember that day I got home from class around 5, because I got out of class around 4:30 usually and walked home, so I would have gotten home around 5:30, and it would have been after because I came home, I made myself lunch, and I took a shower, and then I heard all of their arguing. So it would have been about an hour and a half, 2 hours after I got home, so around 7 to 8 o'clock.
Okay. And during that time, when you say arguing, was it back and forth?
I honestly, I wouldn't really be able to say if it was back and forth. I don't know I wouldn't remember too vividly if it was back and forth. Or if it was
Let me
just
ask you
one
this:
person
Did you
yelling.
hear a male voice?
Yes, I heard a male voice.
Did you hear a female voice?
Yes.
Okay. Were they both loud?
Yes.
If I can confirm, Judge.
Yes, sir, of course.
Thank you, sir. I have no further questions.
Any redirect?
No, Your Honor.
Can this witness be released?
Yes, Your Honor.
Subject to recall, Judge.
All right. All right, sir, you're released subject to recall. Thank you. Can the parties approach? Members of our jury, thank you so much for your time, your attention, and your participation in this very important process. It is 12:21. At this point in time, we're going to go ahead and take our lunch break. I'm going to ask that you return here no later than 2 p.m. so we can pick up at that point in time outside of here, 12 Alpha in the Orange County Courthouse. And I'm going to give you an instruction. You're going to hear this instruction a lot over the next couple of days. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors, do not watch local news or read local newspapers. Jurors must not have any discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, please leave your pens and your notepads on each chair. The deputy will collect them. We'll see you at 2 o'clock, and I thank you for your service.
Welcome to Vinnie Politan Investigates. I'm Julia Janae, filling in for Vinnie, and the subject of our investigation is Sarah Boone, a woman accused of killing her boyfriend with a suitcase. The image of Jorge Torres shocked the public. A man zipped up in luggage, unable to get out despite his furious attempts, while his girlfriend recorded it all with her cell phone and taunted him as he struggled to get out. Here's the story. On February 23rd, 2020, Sarah Boone and her boyfriend, Jorge Torres, were spending an evening together at Sarah's home. The couple had a bit of a tumultuous past. Both had been arrested on domestic violence charges, but they always seemed to get back together. On this night, the two were drinking. But what happened next is inexplicable. George got inside of a suitcase that was then zipped shut. Why and exactly how he got into that suitcase is not 100% clear. But what is clear is that at one point, he wanted to get out. He pleaded with Sarah to open the suitcase, but she refused. Instead, she turned on the video camera on her phone and started to record as George begged for his life. Still, she refused to unzip the suitcase. Then the following morning, she eventually called 911. She said she and George were playing hide and seek, and George ended up in the suitcase. When police responded, they found George dead in that luggage. Sarah has been charged with second-degree murder, and she claims she was the victim. She's claiming battered woman syndrome. What happened inside of that apartment, and why was George in that suitcase? Now, since the beginning, this story has revolved around the suitcase video. It's not every day where we have a case where the defendant filmed this alleged murder that the person who's on the stand, who's going to be testifying, but is charged with this murder, second-degree murder. And due to its graphic nature, it was named as one of the two reasons that law enforcement believed that they had probable cause to charge Sarah Boone with second-degree murder. It's likely going to be the hardest obstacle to overcome when convincing the jury of Boone's innocence, which is what the defense is going to try to do. In order to truly understand this case, it is crucial to watch the video. But I do want to warn you before we show it, the footage is graphic and hard to watch.
Sarah. For everything you've done to me. Sarah. for everything you've done to me.
Sarah.
You.
Sarah.
You.
Sarah.
Stupid.
Sarah.
That's my name. Don't wear it up.
Sarah. I can't breathe, babe. Seriously.
Yeah, that's when you do when you choke me.
Sarah. 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 Sarah, I can't breathe, babe.
That's on you.
Sarah, I can't breathe.
That's on you.
Sarah.
Real or handsome. I want to get video for it extra. Because I got this.
Sarah.
Real or handsome.
Sarah. Sarah, I can't breathe, babe.
Oh. That's what I feel like when you chewing on me.
Sarah.
You.
Breathe, Sarah.
Yeah. You should probably shut the up.
Sarah.
This is evidence that's never easy to watch, no matter how many times we play it here on this show. And you can hear not only Jorge Torres, his pleas for help. That alone is enough to feel horrifying. But then to see and hear that Sarah is taunting him and not doing anything about those pleas for help. This jury is going to have to understand what Jorge Torres went through. The prosecution wants to make that clear for this to rise to not manslaughter, but second-degree murder, that she had a reckless disregard and depraved heart for his life. So just how traumatic were Jorge Torres's last moments? That's our question at the top of this hour for the show. And we have experts who are going to talk to us about what it was likely like for this victim. So to help us answer this question, let's bring in our experts. Joining us now, psychotherapist and CEO of Life Counseling Solutions, Dr. Janie Lacey is with us, and also joining us, forensic death investigator, professor of forensics at Jacksonville State University, and host of the Body Bags podcast, Joseph Scott Morgan is here. So Dr. Lacey, let me start with you. We're talking about how mentally and psychologically this could be quite traumatic for someone. What do you think about when you see a video like this?
Well, you're absolutely right. It's heartbreaking to watch, as we know that we are watching the last moments of Jorge's life. But when we consider, especially the reports that are coming out, and you take into context probably what happened to him before she turned on that video. So if there was already some types of discord between the two of them and what happened, that he got into that suitcase, all of these answers that are yet to be answered. But we know that he was suffering. He was pleading for her. He could not breathe. And she's on the other side, taunting him, finding it funny with her slurred speech and bringing back some of the retaliatory statements of things that she feels like that he's done to her, and to sit there and to hear him plead for his life. So we know he was suffering. There probably was a lot of fear, and especially depending on what was happening between the two of them before she actually filmed. All of that stuff really matters to what he probably was experiencing inside that suitcase.
Dr. Joseph Scott Morgan, let me ask you about the physical part of this, because we're understanding what he may have been thinking about, but what was this like for his body to be inside of that luggage?
Well, he's in a contracted position. Let's keep in mind that when they originally released the cause of death, they talked about suffocation. Let's be more specific than that. This is a positional asphyxiation. So what that means is that, as demonstrated in the suitcase in this horrific video, he's in a contracted position. So his arms are pulled in, knees are pulled up. And he's inside of the suitcase that is probably not gas permeable. So that means that you don't have a lot of inflow of oxygen. And so with every respiration that he takes, he is taking in the remainder of the oxygen that is in there, and then he expels the carbon dioxide. And here's one of the things that happens. You develop a condition called respiratory acidosis, which comes along with this idea that your uptake of carbon dioxide is outpacing your uptake of oxygen. It's very painful. He would have gone through these stages of shallow respirations. He still has an awareness. He has enough of awareness where he's begging for his life. You can hear in his voice that he's distressed. And here's one interesting thing that she said that really stuck out to me. She actually said something, and I'm paraphrasing here, but I heard in the recording, he's talking and asking her to let him out. And he's saying, I can't breathe. And what does she say? She says, well, I guess you ought to be quiet. That goes to depraved indifference, perhaps, because she has an understanding the more you talk, the more oxygen you uptake. Therefore, he's on the road to death.
And that's what prosecutors are going to be emphasizing. How much did she understand about the dangerousness of this? And to really understand it, we want to look at this timeline, because we just showed you, it felt like a long time when we watched that clip, but it was 2 minutes long. That's not anywhere close to how long he was inside of that suitcase. So based on the documents that we have looked over in this case, we were able to put together these key times. And that includes, we have the arrest affidavit. It states that the first video where she began recording was at 11:12 p.m. And then she decides to go upstairs a little over an hour later and fell asleep after about 30 minutes. The following day, she woke up at 11 a.m. and realized that George was still in the suitcase. So if what Sarah Boone said, if she was truthful in her retelling of the events, George would have been in that suitcase for 11 hours and 48 minutes at the very least. Dr. Lacey, even if he had survived this, what would that kind of an experience be like for someone who, after all of those hours, had been in a situation of being trapped?
Well, not to mention the physical implications, but when we think about the psychological implications, right, there's going to be a lot of PTSD, right, the claustrophobia, a lot of different things that he probably would have gone through, and probably the state of their toxic relationship. All of these things takes him to this edge where she's entrapping him and allowing him to suffer and to beg. And then for him to potentially have survived that, there would probably have been a lot of implications to him having PTSD, anxiety, depression, probably a lot of revenge thoughts around this relationship. So we can only imagine what he was thinking in those final moments, because we can hear him suffering and her on the other side of that, to know that someone that you love has the potential to let you free and to not allow you to suffer, and then to hear her on the other side, I could imagine was very, very difficult for him.
We've got a bit from the autopsy report that lets us know the condition of his body. According to that autopsy, he had long nail scratches to his mid-upper back, a large nail scratch to the back of his neck, contusions to his left shoulder, left skull, and forehead contusions considered to be blunt force trauma. He also had a cut near his lip that was busted. Joseph, just talk to me about what you think the cause of those injuries were. I mean, could he have gotten those just from being inside of the suitcase? Because Sarah Boone told police she was shocked that he had those injuries and said to police, "You don't think that was me, do you?"
Well, that'd be really interesting. When they finally addressed her and began to examine her at the scene and chat with her, I'd really wonder if she had any injuries on her. Again, if he's, say, for instance, if he has any agent on board where he could be compromised, his ability to fend for himself, if he was intoxicated at any level, any drugs on board, she may have been struggling to get him in there, and she's trying to subdue him. That's a possibility. Now, could he have generated those injuries inside of that suitcase just by flailing about in there? I suppose that he could. I'd be fascinated to know what his actual position was inside of the suitcase relative to the floor. And if you could see that image once more of that suitcase, when you see it, I find it fascinating that as you're looking at it, the zipper side of that suitcase is actually down, touching the ground. It's not up. So this thing had to have been moved. The big question here scientifically is, could he have leveraged this thing enough just through the motions of his body to flip it over and it wind up like that? Or did she place him in there and then flip the suitcase so he would not have an opportunity to get out of this thing, perhaps, because he's so disoriented?
Investigators do believe that she was involved in pushing that suitcase over. So the question is, will that be something that she admits to at any point in this trial? We are going to take a break. Don't go anywhere. Our guests are staying with us. We're attempting to answer our next question in this investigation. Just how intoxicated was Sarah Boone when this happened?
You told us you weren't drunk. No, I was not drunk. Right. I was not drunk.
Are you incapable of telling the truth, Brian? On the premiere of Interview with a Killer. The problem is people don't believe me. A gruesome torture caught on camera. You told the police that you shot her because you wanted a Hollywood moment. The monster behind the memory card murders is speaking out. That sounds like a guilty man who's coming clean. Interview with a Killer. Series premiere Sunday, 8/7 Central on Court TV.
I was in shock. I was traumatized by the situation, and then trying to focus on everything that was going on at my home. I was hungover. I was still, I believe, intoxicated to a degree.
That was Sarah Boone on the stand during a previous hearing in her murder trial. She was describing her state of mind during her police interview the morning of George Torres's death. She claimed she was hungover, possibly still intoxicated from the night before. And it's a large point of contention in this case because according to prosecutors, one of the many ways her story is consistent is about whether or not she was intoxicated. Take a listen to how she described her drinking that night in her police interview.
You told me but you told me on recording, like, that you were not drunk, he was not drunk, you guys were having a good time. I can't get drunk. Number one, I do not want to get drunk. I don't like being non-complimentous, having my wits about myself. I don't like feeling out of control. Mm-hmm. So I'm just saying, you're making it sound like he's a raging alcoholic today, and yesterday I was kind of asking you those questions, and you're like a little defensive, like, no, we're not alcoholics. I'm not. We are not, but you guys were both sober on Sunday, to your knowledge, because when I said you went and passed out, you were like, no, I didn't pass out, I just fell asleep. So now it's kind of like, what is it? Were you guys drinking and it got out of hand and it got physical? No. Or is it? Sunday was one of the better days that we have had in quite some time. So where were you guys at on drunkenness, not drunkenness on Sunday? You told us you weren't drunk. No, I was not drunk. Right. I was not drunk.
So Sarah Boone has admitted to drinking alcohol, but she repeatedly has affirmed that she wasn't drunk. So that brings us to our next question. Was Sarah Boone intoxicated when this happened, when George Torres was inside of that suitcase? Let's bring back in our guests, still with us, psychotherapist Dr. Janie Lacey and forensic death investigator Joseph Scott Morgan. Dr. Lacey, you heard Sarah Boone there saying, first, I can't get drunk, and then she says, I won't let myself get drunk. What is that saying to you?
When I hear statements like that, Julie, I often think about clients that we work with that either have some level of alcohol abuse to alcohol dependence. So when there is some level of struggle, then there's also a huge window of denial. So my mind goes to, with that defensiveness, I'm wondering what her history of alcohol was. But when we're watching the video and we're hearing the slurred speech, and we're also potentially hearing the executive functioning going offline, so to speak, week and not really thinking through the consequences of her behavior, right? Some of these things are consistent with someone that is at least abusing alcohol, where they're not being consistent with thinking through with their executive functioning, thinking through consequences, and we're hearing her slurred speech. So there would be some assumptions based off of what we see and what we know that there is some level of being influenced by alcohol consumption.
And perhaps what we hear in that video, Joseph, we are hearing her words. It sounds like there's a slur. What are some of the steps that would have been taken by authorities if they would have been able to determine her level of intoxication, knowing that this was the morning after?
Well, you know, if this had been interdicted immediately, I would think they could have perhaps have done a blood draw. But in that same vein, I got to tell you this. And look, I understand that this was not a traffic stop, but I can tell you this: if she had been operating a motor vehicle and police pulled her over, she rolled down the window to communicate with a police officer, and she was speaking like that with that slurring going on, guess what's going to happen? They're going to take her out of that vehicle and they're going to subject her to a field sobriety test, because that in and of itself, just the slurring of the speech, would be enough for them to have reason to do that. And it's fascinating here for me just watching this, because you have this almost in real time and she's recording herself doing this. And it kind of reaches out into the realm of the absurd. Where she's saying definitively, I wasn't drunk, I can't get drunk, but yet you have her here where her ability to vocalize things is compromised. And so my next question would be, well, are you physically impaired some way? Are you on some kind of medication? Because, you know, this just doesn't sound like someone that has their wits about them.
So Dr. Lacey, she's saying that she can't get drunk, even though we know years after this, her attorneys are going to put down on the record that one of her defenses is voluntary intoxication, hoping to save her life, hoping to get a lesser charge in this case. But it doesn't seem like she wants to admit that. What do you think is the reason behind that? Is there some kind of shame there that she does not want to admit to authorities?
Well, when I hear people say statements like we heard Sarah saying that she can't get drunk, there's usually some context around that, meaning that in my experience, usually when there's some level of those statements, it's because there's some type of history, or people will say, can't get drunk because of this. I can't get drunk because I don't remember things. I can't get drunk because I tend to say things, right? There's usually some type of following statement that people will make, at least in the counseling realm. So when I'm hearing that statement on the video, I would be wondering what her context is, and that would be dealing with her history. Does she black out? Does she normally get violent? Does she say things that she tends to regret, right? So usually when people try to be defensive because they don't want to allow themselves to consume a certain level of alcohol, there's usually because there's a reason behind that, and that reason is something that they don't want to show up in their life. So that is where I would imagine there's some context there to that statement for her and her history.
Joseph, I only have 10 seconds. Do you think a jury will think she was intoxicated?
Yes, just hearing that, hearing the recording, yes, I think that they probably would.
That's all the time that we have. Thank you so much to our guests, Dr. Janie Lacey and Joseph Scott Morgan, for lending your expertise. We know your time is valuable. I'm Julia Janae. We're going to keep digging for answers as the investigation continues. Welcome to Vinnie Politan Investigates. I'm Julia Janae, filling in for Vinnie as we continue our investigation into Sarah Boone, a Florida woman accused of killing her boyfriend with a suitcase. She's charged with second-degree murder, but she has firmly maintained her innocence for years, going through 8 attorneys and turning down plea deals for a lighter sentence. She says this was an accident and not at all her fault. Here's the story. Sarah Boone and George Torres were involved in an on-again, off-again, tumultuous relationship filled with accusations of cheating and abuse. But on February 23rd, 2020, Sarah and George were together at her home, spending some time together and drinking. But at some point that night, for some reason, George ended up locked in a suitcase while Sarah taunted him as she recorded video with her phone. George tragically died that night, and now Sarah is facing murder charges. There are still many lingering questions in this case about their relationship and exactly why Sarah didn't open up that suitcase and let George out. Now, since the beginning of this case, many of our legal experts have struggled to come up with an effective defense for Sarah Boone in their analysis of this case, especially after seeing that notorious video discovered on her phone. So when Boone landed her 9th attorney, and it seemed like he was the only one who would finally see this case through to the end, we were all wondering what would be his strategy. Then, out of the blue, attorney James Owens made it known he was going to be trying to defend Boone at her trial. The declaration that not only surprised us, but the judge as well. Take a look.
Judge, the state doesn't know what happened the 2 minutes prior, or the minutes leading up to, the time leading up to the 2-minute video. The state doesn't know what happened after the 2-minute video. Only Sarah Boone can testify to that. That's for her to testify to.
Florida, the appellant has not cited, nor is our research located, any Florida case holding that evidence of battered spouse syndrome is admissible where the defendant claims accident rather than self-defense.
Who claims accident?
Are you claiming self-defense?
Yes.
Well, that's the first time that I've heard that.
Judge, I just mentioned it a while ago.
The word self-defense never came out of your mouth.
Judge,
words that you believe that the state's position is, what you believe that they're going to try to establish, that we don't know what happened before and after that video. The word self-defense have never been uttered this afternoon.
Judge, for the record, we're claiming self-defense. We're utilizing the battered spouse syndrome in conjunction with that defense.
Okay. All right.
Not accident, as they want to allege.
Okay.
This declaration transformed how things develop inside of that courtroom now. So after hearing James Owens' plan for Boone's defense, we're left with one looming question, and it's a big one. We're asking our experts, is battered partner syndrome in this case a legitimate defense for Sarah Boone? And to answer that, let's bring in our guests who are standing by. Joining us, the state attorney for Palm Beach County, Florida, Dave Ehrenberg. Also joining us, the co-host of the very popular Surviving the Survivor podcast, Joel Waldman, joins us on the phone. Dave, let me start with you. This was a moment inside of the courtroom because we didn't expect that this is what she was going to be arguing. We had seen other filings saying voluntary intoxication, perhaps accident, but this is a difficult defense, is it not?
It is, Julia, but this is what happens when you have a client who demands things go her way. That's why she's on her 9th lawyer. She's had irreconcilable differences with the other lawyers because she wants to prove her innocence. Not that she's lesser culpable of manslaughter instead of murder. No, she wants to say she's innocent by way of self-defense. It means she's going to have to testify. But even if you claim this battered spouse defense, it means that you still have to show that you were in threat of your life or at least great bodily harm. Well, she was the one in control here. She was the one taunting the guy. He was stuck in a suitcase. He wasn't a threat to her at the time. And if she really was threatened by him, if she really was that scared of him, why are you playing a game of drunken hide and seek with him? So none of the facts seem to justify her defense.
Joel, you have been inside of the courtroom for arguments leading up to what is going to be this huge trial. What has been the conversation about battered spouse syndrome and whether they can even present it to the jury, because that hasn't happened yet?
Good evening, Julia, and I apologize that you're not seeing me on camera, but I have a face for radio. Better off that you are looking at Dave. I will fix the problem.
That's fine for now, Joel.
To answer your question succinctly, people across the board just think it's absolutely, for lack of a better word, insane. I've talked to a lot of smart legal minds like Dave and criminal defense attorneys, one in particular who just won a battered spouse case out of Palm Beach County, I believe it was, where Dave is. Her name is Jessica Mashali, an attorney. And she said, look, Sarah Boone does not exhibit any of the traits of a battered spouse, absolutely none. She said to me, why don't they just say it was an accident? And you just heard in that soundbite you played that they don't plan on doing that. Why don't they just say that she was drinking, which she was, she passed out, she fell asleep, and next thing you know, she woke up and Jorge Torres was no longer with us. It's obviously a horrible tragedy. But then you got the fact that she also videotaped all of this, which police have, and that videotape, I don't think any jury will be able to get around that.
Yeah, the prosecution does not want this defense coming in. Here's a listen to what they had to say in trying to get the judge to keep it out as an option.
If this is what she says, does this amount to what they're asking for legally? And it's the state's position under the case law that no, because under her statements that she gave to the experts, there was no overt act taken by the decedent on that day. There was no overt action. And that's what's required under the law to trigger her response of acting in self-defense. They're laughing. It's all fun and games still. There's still no overt act taken by the decedent during this entire calendar day to put anybody in reasonable fear, objectively reasonable in fear of imminent harm, of great bodily harm or death. And it's only when he begins to say, after she has zipped him up into the suitcase. Again, she is saying that she did not have malintent at that time. When he starts to say, I cannot breathe, now she describes to the doctors that she does have bad intent. And she wants him to feel what she has felt in the past. She gets angry, is her description. She shakes the suitcase, she beats it, it falls over, it flips over. He sticks his fingertips out, she hits him with a bat. So she's now the initial aggressor, and we'll discuss jury instructions as we get closer, but she's the initial aggressor, and she has now committed forcible felonies, aggravated assault, and aggravated battery, stating that I only intended to keep him in there for a couple of minutes. I believed he could get out. She never perceived, according to her, that he would die or face great bodily harm. And she just goes upstairs knowing now he's mad because she won't let him out. Now, because of the actions she took as the initial aggressor, she is facing death or great bodily harm from the decedent if he gets out. And she completely expects him to get out because her testimony is that he could get 2 fingertips out of the zipper. So, Your Honor, under the law, the state understands. We are deeply, deeply thoughtful about this request because of the risk of error. But this is just one of those cases, like the cases the state cited. There is no self-defense if that is what her testimony is.
So Dave Ehrenberg, you hear there, the prosecution says you still need an overt act for battered partner defense to work. Talk to us about the difference between battered spouse and self-defense when you don't have to necessarily show a cycle of abuse.
Yes. And by the way, I thought Joel Wallman did a great job, even without video. He's an A-list guest, definitely. And I thought that prosecutor was right on the money. You know, battered spouse offense is not a substitute for self-defense. You still have to show that you are in reasonable fear of your life, and it's an imminent threat. So if she says that, well, he poked his fingers out and he was trying to grab at me and choke me, that would be something. That would be an overt act. But he didn't. He was just trying to get out of the suitcase, and she was the one in control. She was the one taunting him, and the jurors are going to hate this person, this defendant, because she lied to police. She was the aggressor the whole time, and now she's trying to cloak her whole case on this defense that is really not applicable to her. She would have been better served just saying that I got drunk, I didn't mean for this to happen, it's an accident, give me manslaughter, lesser offense, I'll be out in 13 years. But no, she insists on being acquitted, and she's not going to be.
So she's been offered that lighter sentence. She's turned it down. Joel, tell me about what you've been hearing. You're there on the ground, but you're also talking to viewers all the time of your podcast about this case. How shocked are people that she turned down a deal which could let her out in the next 8 years or so?
I mean, there's one word, incredulous. People cannot believe it. You know, she served, people don't realize she's been sitting in jail since 2020. She served over 4 years in jail and was offered a plea deal. And people are upset that she was actually offered this deal. She could have been out with time served in something like 8+ years. You could tell that her defense attorney, by the way, this is her 9th defense attorney. His name is James Owens. He said today in court, he only got the case 45 days ago. You could tell he was trying to steer her towards taking the appeal, but by all accounts, she's an absolute control freak, and she thinks she is smarter than everyone in the room. If you watch the police interviews, that is abundantly apparent. And because of this, she's going to go to trial, and you know, the betting odds are against her. Most people think she's going to get convicted with a harsh sentence. So I just don't know what she's thinking here.
And Dave, you're there in Florida. You are a prosecutor, a state attorney there in Florida. So I'm really trying to dig into battered woman syndrome and how we know that it is a different perception in terms of it's from the perception of that woman who is in this situation. And correct me if I'm wrong, but should we or should the judge be looking more at how Sarah Boone says this all went down? Because she said that she had to hit his fingers with a bat to keep him from coming out of this suitcase. So if she was in fear for her life at the time, she's got this cycle of abuse that she is claiming, and there's some evidence to back it up based on the arrest reports where both of them have been arrested for domestic violence. A lot of those charges didn't stick. But should there be more emphasis on what Sarah Boone was feeling? There's a look at the filing where the defendant said to her psychiatry evaluator, who said that she shook the suitcase, she lost control, the suitcase flipped, and then she hit his fingertips with that baseball bat that was in the room. Is that not enough?
No, because although you do look at it through the eyes of the person claiming battered spouse syndrome, it's got to be filtered through the prism of reasonableness. Was it reasonable for her to have a fear of her life? The guy was stuck in a suitcase. She was in control. And the little part that he was able to put his fingers out to try to get himself out. And then she had a bat, a weapon. He didn't have a weapon. He was pleading for his life. She was out there taunting him, saying, yeah, that's my name, Sarah, don't wear it out, which is like an 80s line. Shame on her for that. So no, it's not reasonable. And that's the problem here. And one other thing, I know you call it battered women syndrome. In recent years, because any gender could take use of this, it's now called battered spouse syndrome, but it is the same thing. You do look at it through the person's eyes, but it's got to be filtered through the prism of reasonableness. We are going to keep talking about this case. Our guests are staying with us. Don't go anywhere. We have our next question that we're going to pose in this investigation into Sarah Boone's case. What is it going to be like when she takes the stand?
The state doesn't know what happened after the 2-minute video. Only Sarah Boone can testify to that.
One of the most successful true crime TV shows ever.
This is crazy.
Now has a new home on America's original true crime obsession, 48 Hours on Court TV. Coming up next on Court TV.
Sarah Boone is charged with second-degree murder after her boyfriend suffocated inside of a suitcase.
Sarah, I can't breathe, babe.
I thought he was okay.
The Suitcase Murder Trial. Live coverage weekdays, 8/7 Central on Court TV.
I tried giving you CPR. The problem is I fell asleep. I fell asleep. When did you do CPR? This morning, when I found it. Before you called? Yes.
1 o'clock right now.
I tried. I was awake, but I actually got out of the bed at like 12:30ish, whatever. So I came downstairs, and I was like, oh, he's in the suitcase still.
Throughout the pretrial hearings in this case, over and over again, we've heard a common theme, and it has to do with Boone's upcoming trial. Take a look.
The state doesn't know what happened after the 2-minute video. Only Sarah Boone can testify to that.
This evidence can only come from her. So she should have to testify.
What does Ms. Boone, in this case, testifies to on the stand?
If the defendant's going to have to testify in a narrative form, if she's going to come in and testify 100% differently than how she gave statements to law enforcement, I believe the crux of that issue is going to revolve around her having to testify in the form of a narrative given her prior statements.
That was defense attorney after defense attorney making it seem like it's almost inevitable at this point that she is going to be testifying. So we are left with one final question, and that is, what is she going to be like on the stand? After everything we've heard from Sarah Boone, let's bring back in our guest, still with us, State Attorney for Palm Beach County, Dave Ehrenberg, and on the phone, co-host of Surviving the Survivor podcast, Joel Waldman is with us. Joel, let me start with you. What do you think Sarah Boone will be like on the stand? You've seen her in court, and sometimes she's had to speak up and talk directly to the judge.
Yeah, look, I don't want to make light of this. If you've seen the suitcase video, as it is now known, it's horrific. Jorge Torres is in there. He is suffering. But she is going to be wild on the stand, and it's going to make for must-see TV. And I hate to minimize, someone's loss by saying that, but it is true. I was probably 8 feet away from her today. She's just nonstop fidgeting. She's, just constantly in motion. And her stories are very inconsistent. 1 minute she was saying she was drinking, the next she's not drinking. 1 minute she's saying everything was fine between her and Jorge Torres. The next minute everything was not fine. She can't keep a story straight. And this is a very seasoned prosecutor, Will J. And he is going to trip her up, and she is going to suffer, in my opinion, as a result of testifying, which I think there is no way out of for her.
Dave Ehrenberg, this testimony in the narrative style, what is that for in this case? We've seen it in other cases, but it's usually when a defendant is either representing themselves or they told their lawyer something they shouldn't have.
Yeah, that's generally what happens. That's what that case was about in Las Vegas, the Telus case. We saw it there because the guy was a liar and the lawyer didn't want to be part of it. And I think that when you have so many contradictions, the lawyer doesn't want to suborn perjury. So they just put the defendant on the stand and say, all right, tell your story. And this also shows you that the defendant is insisting on this defense and is insisting on taking the stand and telling her story, looking like it's against the wishes of her lawyer, her ninth lawyer, as Joel correctly put it. So it will be must-see TV. The jurors are going to hate her. She is someone who's already unlikable without saying a word at the table by fidgeting and talking her lawyer's ear off, passing him notes, and then making demands like Pop-Tarts. She has the diet of a school child. So I think that this is not going to go well for her. She should have listened to her lawyers, but this is how she got to where she is.
So this narrative style means her attorneys aren't going to be asking her any questions. Joel, when this starts, you've seen her police interviews. You've seen how she seemed to just stick to, how could you believe this was intentional? I didn't do this intentionally. What do you think she's going to be like in terms of staying on task on the stand?
A disaster. I'm no psychologist, but if I had to diagnose her, I would definitely put ADHD in there. And again, I am not a therapist of any kind, but my parents are and were. And, I'm just observing her in court, and Dave is 100% right. She's spending the entire time either taking notes or talking her lawyer's ear off. Yesterday, she kind of swung around and was whispering back and forth from a distance of probably 15 feet because he was in the gallery, but she was talking to the private investigator, and she just cannot seem to keep a focus. And so I think it's going to be really hard. That's going to translate in terms of not being able to tell a story because of this lack of focus. She's going to be all over the place. And again, this prosecutor, Will J., he has been around since the 90s. He's got a lot of experience, And I believe he's going to run circles around her.
Dave, what do you think about this element of her believing, it seems firmly, that this was not intentional, therefore I should not even be arrested? The detective said that, hey, even if it's not intentional, that doesn't mean you didn't do intentional acts that led to this. And the judge is going to keep that part of the interrogation out so that the jury doesn't get confused by that being a legal conclusion. Your thoughts on if that was the right move?
Yeah, it's the right move. The jury's going to see her lie on camera where she said, I fell asleep. And then all of a sudden the videos are discovered on her cell phone and she looks not only like a liar, but a murderer. And so when she tries to have all these different explanations, yeah, it's good that the court is going to take control and limit the kind of defenses and the kind of things she could say, because, you don't want this to become a circus. It's already going to be a circus if she's allowed to testify in the narrative. She is not going to make a good witness, but at least you got a judge who has control over his courtroom.
Absolutely. It is going to be a trial that we will be watching every second of. Dave Ehrenberg and Joel Waldman, thank you so much for being with us. We certainly appreciate your analysis and expertise. Now, Sarah Boone's fate in this case, it's going to soon be in the hands of the jury. They're going to decide what happened to Jorge Torres. Was it murder? They'll decide if he was a victim or if she was the victim that night. Looking at the facts and the law is what they are going to be using. Now, she's innocent until proven guilty. It's her right to testify, her right to remain silent. But the fact that she is exercising her right to counsel and now has an attorney rather than representing herself means a better chance at fair administration of justice, no matter what side you're on in this case. I'm Julia Janae. We'll keep digging for answers as the investigation continues.
All right, we're back on the record. State of Florida versus Sarah Boone, 2020 CF 2603. Can I get appearances for counsel for the record, starting with counsel for the state?
Dave Castro on behalf of the state.
William J. for the state.
Defense.
James Oldham for Sarah Boone.
Tony Henderson for Sarah Boone. Kevin Beckham against Sarah Boone.
Ms. Boone is seated at counsel's table wearing the same black suit and pink blouse from this morning. State, anything we need to address before we bring back in our panel?
Can we get the evidence projection system up and can we test it before we
Yes.
go live?
Yes, sir. If you want to test it out, Mr. J.
Call 1 at 12:59 p.m. with a GMT offset of minus 300 minutes. Call on month. Call 1 at 12:59 p.m. with a GMT offset of minus 300 minutes. Call on Monday, February 24th, 2020.
911, what is the location of your emergency?
That is the best I can do, sir.
We're here today.
Okay, all right. Anything else, state, we need to address?
Not this time, Your Honor.
Defense?
No, sir.
Okay, all right. Just in the spirit of full disclosure, there are some persons behind me to my right and my left. I run the mock trial program at Barry University School of Law here in town, and these are some of my students as a member of that program, so they're here just simply to observe. So pay no mind or attention to them. With that, are we ready to bring in our jury?
Yes, Your Honor.
Yes. All right, let's stand and bring in our panel.
Jury entering.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury? Yes. All right, y'all can be seated. Thank you. Members of the jury, good afternoon. I hope you enjoyed your lunch. If you could, again, by a show of hands, confirm that you complied with the court's instructions that we gave prior to the break. Record reflect all jurors' hands have been raised. With that, the state is going to continue with their evidence presentation this afternoon. State, you may call your next witness.
State will call Brian Boone.
Mr. Boone, raise your right hand and be sworn, please. Do you swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Sir, good afternoon. You could be seated. After seated, if you could please state and spell your name for the record for us.
Brian Boone, B-R-I-A-N-B-O-O-N-E.
Thank you, sir. You may inquire.
Good afternoon, sir.
Good afternoon.
Can you tell us how it is that you know the defendant?
I dated her for quite a while, and then we eventually got married.
When you say you dated her for quite a while, how long are we talking?
I met her in the late 90s, and I believe it was around 2005 when we got married.
Did you have any children as a result of your marriage with the defendant?
Yes, we had one son.
And how old is that son?
He is currently getting ready to turn 14.
Did your marriage with the defendant last?
No, it did not.
And approximately when was it that you separated and began proceedings for divorce?
Probably 2017, I'm thinking maybe.
And at that time, when was your divorce actually finalized?
Oh, maybe it was 2016. I think the divorce was 2017. I believe.
And after your divorce, what was your custody arrangement with your son that you had in common with the defendant?
She was supposed to have him on Mondays and Tuesdays. I would have him Wednesday, Thursdays, and then we'd alternate Friday through Sundays every other week.
So 1 week you would have 5 days with your son, and another week she would have 5 days with him.
Correct.
And was this still the same custody arrangement in February of 2020?
Yes.
And in February of 2020, do you recall the events that occurred, I guess, first on the late evening of February 23rd, 2020?
On that evening?
Yes.
Well, apparently Sarah called me at one point during the night.
Do you recall about what time she called you?
I think it was 11 something.
When you answered the phone, how did Sarah sound on the phone?
She sounded like she had been drinking, was pretty drunk.
Were you able to understand what the defendant was saying?
Somewhat, but she woke me up. I had work the next day. I was asleep when she called. She's done this before, calling me late at night, and generally I kind of just try to ignore it, so I wasn't really paying attention.
Who was she living with at the time?
Jorge Torres.
When she called you late that evening, could you hear George in the background at all?
Not that I remember, no.
Did you pay much attention to this phone call?
No.
Now, the following morning, on February 24th, 2020, did you begin to call the defendant?
Yes, I did.
And approximately what time did you begin to call the defendant?
I think it was like 11 o'clock or something.
And why was it that you were calling her?
Well, it was going to be Monday. I had him on Sunday and dropped him off at school, and I was calling to try to find out if she was going to be actually picking him up that day.
Why would you have a question about whether or not she was picking him up?
She wasn't generally very good about actually getting him on the day she was supposed to.
So it was not uncommon for you to have to remind her to pick him up or to make sure that she was going to pick him up?
Well, I mean, remind or just find out if she was going to, or if she was just going to give him over to me as what happened.
Do you remember at what time on February 24th you actually got in touch with the defendant?
I think it was like 12:30 or something.
And when you actually got in touch with her, what did she tell you on the phone?
That George was dead, and if I would come over.
Did she say what happened to him?
I don't remember if she told me then on the phone or when I got there, but she told me they had been playing hide and seek and that she fell asleep.
What did you advise her to do?
I told her she needed to call 911 and that I would come over as soon as I could.
And this is on your first phone call here at approximately 12:30.
Yes.
On 2/24/2020.
Yes.
Did she call you again while you were en route to her residence?
She did. She called to find out if I was still going to be coming over.
And when you spoke with her while you were en route, what, if anything, did you advise her?
I told her she needed to call 911 and told her I was on my way, but she needed to get somebody over there.
How long did it take you to arrive at her residence?
From the first phone call, or?
Yes, from the first one.
Well, I mean, I live a minute or two drive away, but I had to get my puppy. We had just gotten a puppy recently. I had to get him in his crate and stuff like that and put something on because I was working from home. And total time, maybe 10 minutes.
When you arrived at her apartment, tell us what she told you when you arrived.
George was dead, and I don't remember if she told me now or before that they had been playing hide and seek and she fell asleep. But I at that time told her again she needed to get 911 called to get somebody over there.
Had she called 911 at this point?
No, she had not.
So you've advised her now 3 times to call 911.
Yes.
Did you go inside of her apartment?
I walked in the front door into the little tiled area, like entranceway thing.
What, if anything, did you observe when you made it to that point?
Looking into the living room, I could see like the end of his feet and maybe a little bit of some legs that were kind of coming out around the backside of the kitchen area.
Did you continue to go into the apartment?
No.
Where did you go?
Sarah told me she was going to call 911 and go outside and have a cigarette and a drink and asked me to come out there with her. And I told her that I didn't really feel comfortable being inside. And I went out front and got in my car and waited for people to show up.
Did you witness the defendant call 911?
I think I was in there when she dialed it and first got somebody on the phone, but I wasn't there for the whole conversation. No, I was outside.
Did you stay there at the scene while police arrived?
Yes, I was there. I was part of it. I knew I'd have to talk to somebody, so
Did you talk with law enforcement?
I did.
Your Honor, I have no further questions at this time.
Thank you. Any cross-examination?
Judge, we want to reserve our questions for when we call him in our case.
Okay. All right, sir, you're subject to recall.
Okay.
Thank you.
Thank you.
Just as long as he remains under subpoena.
My understanding is subject to recall.
So somebody will contact me about when we come back?
Yes, sir.
All right, thank you.
Thank you, sir. State, you may call your next witness.
Your Honor, may we approach a moment?
Yes. Members of the jury, we'd appreciate your patience for a few moments while the state attaches a Bluetooth speaker so that they may publish some evidence that's been received so far. Mr. J, whenever you're ready, sir.
Permission to publish 3.
You may do so.
It's 300 minutes. Call on Monday, February 24th, 2020.
911, what is the location of your emergency? 4748 Frank Court, apartment 3. 4748, what's the street name? France, F-R-A-N-T-Z. And the appointment number? 3. Is this a police or medical? My boyfriend is dead. Okay, 7 line for the flight appointment, do not hang up.
Location mercy.
That's good. No, please don't leave. 4748 France Lane, apartment 3, France Court. France Court? Yes.
Okay, is this near Mackenzie Drive?
I don't know where that is.
Okay, right.
It's still with Park Apartment.
Okay, 4748 France, correct?
Correct.
All right, correct. Now tell me exactly what happened there.
My boyfriend and I were playing last night, and
Mm-hmm.
I put him in a case and we were playing, and
Okay.
but kind of hide and seek kind of thing. So I fell asleep, and I woke up, and he was dead in the suitcase. So I don't know what happened. I don't know what happened.
Right, okay, what's your apartment number?
3.
Apartment 3?
Yes, like he had like blood coming out of his mouth, and I don't know, like he had like an aneurysm or what happened.
Right, okay, all right, okay, listen, we're getting another T. All right, okay. Okay,
Now?
okay, 40, yeah, listen, we're on our way there. You're at 407-716-8684. Okay, you hanging from somewhere or what, man?
No, I pulled him out of the suitcase. I tried giving him CPR.
Okay, so he was in a suitcase?
Yes, and I fell asleep.
Okay, how old is he working there? 42-year-old man. All right.
Okay, we're setting up, the sheriff's office over there?
Yes, ma'am.
Yeah, okay. All right, listen to me. Okay, that you need to confirm this. No, right, I understand, you need to confirm this. Is he awake at all? Is he conscious at all?
No, he's purple.
Is he breathing?
No.
All right. I need you to get him on the floor, flat on his back for me, okay?
I did. I tried giving him CPR.
All right.
I tried giving him CPR.
Yeah, okay, well,
Nothing happened. He's purple.
okay, listen, you did the first end of the bill. I need you to get it for me, okay?
What is it?
Is he available?
No.
All right, you right by him now?
I'm sorry?
Are you right by him now?
Yes.
Okay, ma'am, listen, so this, is he cold and stiff?
Yes.
Okay.
Well, he's not necessarily cold, but he's stiff.
Right, okay. All right, listen to me. Listen to me. I want you to lay him flat on his back for me on the floor.
I did.
Removing the pillows, okay?
Yes, I did.
All right, okay. Wait.
Stiff and purple.
Right, okay, listen, okay, man, that's fine. We're still going to put compression to him, okay? All right? Place the heel of your hand on his breastbone, right in center of the chest, right between the nipples.
Yes.
Put your other hand on top of that hand.
Baby, I'm telling you. Just like your hand can tell.
Okay.
Please. Okay, you're girdled.
Okay, listen to me. All right, I want you to place the heel of your hand, okay, right between his chest, right between his breastbones. Put your other hand on top of that hand.
Yes.
We want to pump his chest to be hard and fast. Going to live twice per second.
I'm doing it again.
Okay, no, just keep on pumping. That's all you need to do for me. Keep on pumping his chest for me. I don't need you to stop and talk or anything. I just want you to count out loud for me, okay?
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15. This is nice to me.
Okay, man, just keep on pumping his chest. That's all you need to do for me, okay?
Yes. Come on, please, hurry up.
Okay, ma'am, they're driving here as fast as they can. Okay, don't stop to say hurry up. Just keep on pumping and counting.
I'm still doing it while I'm pumping you, okay?
Okay.
Still doing it.
All right, just keep pumping his chest. Count out, I'll take a count with you.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32. Please hurry.
Okay, ma'am, they're getting here as fast as they can, okay?
He's stiff and he's purple.
Okay, keep pumping his chest for me, ma'am.
I'm still doing it, okay? Still doing it. Still doing the concept.
Right, okay, that's fine. You did a good job. Just keep on doing it for me. That's all right. They're getting there as fast as they can, along with the sheriff's office also, okay?
Please.
Keep on pumping, man. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. Keep on pumping for me, man.
I'm doing it. Believe me, I'm doing it, okay? We're gonna play hide and seek.
All right, I understand. All right, just keep on pumping for me, okay? Okay.
Please hurry.
Right, okay.
Horrible. This is horrific. What happened? Like, what happened?
Okay, man, keep on pumping the chest for me, okay? They're in the parking lot. They should be up there shortly, okay?
I'm still doing it, okay?
All right, okay, good. And you found them in a suitcase, you said?
Yes. We were playing hide and seek last night. I fell asleep. I think they're here.
Right, just keep on pumping the chest until they get over, okay?
I am.
Okay.
I am.
Okay.
I am.
Let that take over for you, okay?
When was the last time anybody saw him? The last time. We'll play hide and seek. He was in the Virginia. Okay. But unfortunately, he's been down too long to record him. Hello, ma'am. So
we're there, obviously.
I'm boyfriend. Is your boyfriend? Okay. Is there any kind of medical? No, not that. Hello?
Okay, hey, man, the time to take care of you, okay? Okay, so we'll see you there.
All right. Oh, ma'am, is still there? Hello? Contact 407-716-8684, reference to mobile data. 1308.
Call has been forwarded to an automatic voice message system. 4.
We're ready to continue with the presentation of witnesses.
Yes, sir. You may call your next witness.
State we call Abraham Moreno.
Mr. Moreno, raise your right hand and be sworn. Please be swear or affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God.
I affirm.
Sir, good afternoon. Could you state and spell your name for the record for us?
Abraham, Abraham, last name is Moreno, Moriano.
Thank you, sir. You may be seated. Mr. Cacciatore, you may inquire.
Good afternoon, sir.
Good afternoon.
Tell us, what do you do for a living?
I'm a maintenance supervisor for apartment complexes.
Is that what your position was back in February of 2020?
Yes, it was.
And what apartment complex?
Tealwood Park Apartments.
And how long did you work for Tealwood Park Apartments?
About 2 years.
And tell us, what were some of your duties in your position there with Tealwood Park?
Daily, I cleaned the grounds, walked the property, answered maintenance calls, did emergencies, dealt with vendors.
Did you become familiar with the residents there at the apartment complex?
Yes.
Did you have occasion to meet the defendant in this case and also a Jorge Torres?
Yes.
Let me turn your attention to February 24th of 2020. Do you recall that date?
Yes.
And on that date, did you have occasion to come in contact with the defendant in this case?
Yes, I did.
And tell us, what was the circumstances in which you came into contact with her on February 24th, 2020?
I was called by the manager and the assistant manager to come to her unit. I believe she was already sitting outside at that time.
And when she was sitting outside of her unit, what, if anything, did you observe about her and about the unit?
The police was there. Her ex-husband was present. She was sitting outside, and that's when she decided she wanted to talk to me and the managers.
And what did she tell you?
She's confused. She's not exactly sure what happened. She pointed out that she recalls that they were playing a game of hide and seek. There was an instance where she was going to teach him a lesson, and then she just doesn't recall anything else until the next morning.
Did she say she fell asleep?
Yes, she did.
Did she say things got out of hand?
I don't really recall that part, but I do recall her stating that they were playing their game and that George went into a suitcase. And I didn't ask any questions. I just let her talk for herself
How long was this conversation?
for about 4 or 5 minutes.
Your Honor, I have no further questions at this time.
Any cross-examination?
Yes, sir.
You may inquire, sir.
Good afternoon, sir.
Good afternoon.
This conversation that you had with Miss Boone,
Yes.
that took place on the 24th? Is that correct?
Yes.
And who else was present on the time that the conversation was taking place?
Standing right next to me would have been Melissa Sexton and Eugene Harris, as well as the officer who was in front of the door.
Okay, so there was a law enforcement officer there that day, is that correct?
Yes.
All right. Now, on the 24th is when you said that Miss Boone made this statement to you. Is that correct?
Yes.
They were playing hide and seek?
Yes.
And what else did she say happened?
She had told me they were playing hide and seek. They had drank. She was trying to teach him a lesson, and that was that. She went upstairs. She went to sleep. She woke up. She doesn't know what happened.
Okay. So that was on the 24th?
Yes.
All right, on the 26th, were you not interviewed by law enforcement?
Yes.
Okay.
I may have my days wrong, but it all happened on the same day.
All right, the 24th, do you remember 2 days later that a Detective Scott Lowen conducted an interview with you at 4704 Lucier Court, Winter Park, Florida? You remember that interview?
Yes.
So that was 2 days later, is that correct?
I would assume so.
Yes. All right, so when he interviewed you 2 days later, did you tell him about this statement that Miss Boone made to you that you just told this jury in court?
I did mention it to him.
You did mention it to him?
I mentioned to them that we did have a conversation.
Did you tell him the content of the conversation?
I may not have told him the whole content, but I did tell him we had a conversation.
All right, well, what did you tell him? What content did you tell him on the 26th?
That they were playing hide and seek, that she was confused. She doesn't know what happened. I do believe I did mention to him the fact that she had said that she was trying to teach him a lesson. Not that anything was done with malice. I didn't state that at all.
So it's your recollection now today that on the 26th, you told Officer Lowen what you just told this jury. Is that correct?
Yeah.
All right. Sir. In preparing for this case, did you have a meeting with the Assistant State Attorney on September 23rd of 2024?
Did I have a meeting?
Yes.
A brief chit chat over the phone.
A brief chit chat, it was over the phone?
Yes, sir.
All right. At that point in time over the phone, did you tell him that Sarah Boone, the defendant, stated that she was teaching him a lesson and things got out of hand and that she fell asleep?
Yes.
Is that what you told him?
Yes.
Okay. And that was in 2024 of September the 23rd of this year, 2024. Is that correct?
Yes.
Are you telling us that back on February the 26th of 2020, You told Officer Lowen at that time the same thing.
As I recall, yes.
So did she ever tell you how things got out of hand?
No.
Sir, you testified that you knew both Mr. Torres and Miss Boone, is that correct?
Yes.
You actually knew George Torres from a different time, didn't you?
Yes, I did.
When did you first know George Torres?
In the 1990s.
In the 1990s?
He was a teenager and he lived down the street from me and my wife.
So you had had a previous relationship with Mr. Torres?
No, not at all.
Not at all. You just knew him from then?
Yes, as I stated, he was a teenager and I was an adult.
Okay. During this time, though, that you became reacquainted with him, did y'all establish a friendship at that time here in Orlando?
I wouldn't say a friendship, but an acquaintance, yes.
Okay. Sir, on Monday, February the 24th, that would have been the day that you were with Ms. Sexton and Gene Harris.
Yes.
Out in front of the apartment.
Correct.
Did you talk to law enforcement that day?
No.
You did not talk to them that day?
I don't recall talking to him that day, no.
Okay. Thank you, sir. I don't have any, if I can confer.
You can, sir.
Thank you, sir. I don't have any further questions.
Any redirect examination?
Just brief.
All right, thank you.
Back in the 90s, when you had previously known George Torres in this case, where were you living at that time?
I lived across the street. I lived on one block. He lived the next block over down in the middle.
In what city?
Philadelphia, Pennsylvania.
And when did you move from Philadelphia, Pennsylvania?
2018.
So in the intervening years, from your move from Philadelphia to coming to work at Tealwood Park, did you have any contact with George Torres?
No, as a matter of fact, I moved from that particular block in 2005. So I don't meet George again until I work at Tealwoods.
When did you start working at Tealwoods?
2018, 2019, roughly there.
No further questions.
Can this witness be released?
No, Your Honor, just subject to recall.
All right, sir. You'll be released subject to recall. Thank you.
Thank you.
State, call your next witness.
State would call Deputy Kayla Rodriguez.
Raise your right hand if you sworn to swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God. Yes.
Good afternoon, ma'am. You could be seated. Please state your name and spell it for the record if you could for us.
Kayla Rodriguez, Kayla, Kayla, Rodriguez, Rodriguez.
All right, thank you. Mr. Cacciatore, you may inquire.
Good afternoon, ma'am.
Hi,
Can you tell us who is that you work for?
Orange County Sheriff's Office,
And what is your position with the Orange County Sheriff's Office?
Deputy Sheriff.
And how long have you been a deputy sheriff?
A little over 8 years, since 2016.
And tell us, what are your duties as a deputy sheriff?
As a deputy, I respond to calls for service, anything from a over with call, like a car being keyed the day prior, or a 911 emergency.
And what type of training do you need to be a deputy sheriff?
So for me, I obtained my bachelor's degree from UCF in criminal justice in 2014. After that, in 2016, I was hired by the sheriff's office. Right after being hired, I went straight into the academy. The academy is 5 months of training. We go over everything from case law, scenarios, defensive tactics, physical training. After that, I do 2 more months with the sheriff's office where we go specifically into policy related to Orange County specifically. After that, I do 3 months on the road with a trainer where we are evaluated periodically through that process. You have a partner, you respond to calls for service during that time, and you slowly learn how to handle calls by yourself.
Do you also undergo continuing training as a condition of your employment?
Yes.
Tell us, what were you working on February 24th, 2020?
Yes.
And tell us, what area of the county were you working in?
Orange County, unincorporated Orange County.
And did you receive a call in regards to this case?
Yes.
And what was that call? What information did you have at the time you received the call?
So the dispatcher informed me that a woman called 911. She was actively performing CPR and that her boyfriend was in a suitcase.
And did you respond out to the scene?
Yes.
And when you responded out to the scene, were you dressed similarly as you are dressed today?
Yes.
And just for the record, you have, it looks like a standard green uniform on with a tool belt, your firearm, and also radio, body-worn camera, badge.
Yes.
Tell us about your body-worn camera.
So my body camera is used to capture scenes when we arrive. So as we are conducting any sort of law enforcement action, we turn our camera on.
When you turn your camera on, tell us, does it immediately capture sound at that point?
It does not. When we activate our camera, it goes back a minute. And the minute that it goes back to, you don't hear any audio for that first minute.
Tell us also about the capacity and the battery life of your camera as well.
So the battery will last us an entire shift typically if it's in a buffering mode. So if we're not recording, it will last the entire shift. As we record, it does drain the battery. So typically we will turn it off if we're sitting in our car for an extended period of time. If we call our supervisor, if we're talking to another deputy on the side, away from a scene, we will not have the camera recording. If it recorded throughout the entire shift, the battery would die. We would need multiple batteries.
So you actually activate the camera in order to begin recording?
Correct.
Was your body camera operational on this call out?
Yes.
Your Honor, may I approach the witness, which has been previously marked for identification as states H, I, and G that have been shown to defense?
You may.
Ma'am, I'm first showing you what's been marked for identification as states I. Do you recognize that disc?
Yes.
Did you have an opportunity to review that disc prior to coming to court today?
Yes.
And tell us, what is that disc?
Body worn camera from the day of the incident.
From February 24, 2020?
Correct.
And is that your initials on the disc?
Yes.
And does that disc fairly and accurately represent the contents of your body worn camera?
Yes.
Your Honor, at this time, I'd like to move what's previously been marked for identification as states I into evidence.
Any objections?
No objection.
All right, what was pre-marked as I will be received into evidence without objection as states 4.
Ma'am, next I'm showing you has been marked for identification as states H. Can you take a look at that disc? Tell us, what is that disc?
Body worn camera from the day of the incident.
From February 24th, 2020?
Yes.
And did you have an opportunity to review that disc prior to coming to court today?
Yes.
And is that your initials on the disc?
Yes.
And does that disc fairly and accurately represent the contents of that portion of your body worn camera from that day?
Yes.
Your Honor, at this time, I'd like to move what's been marked for identification as states H into evidence.
No objection to any of those coming in.
All right, what was pre-marked as states H will be received without objection as states 5.
And lastly, ma'am, I'm showing you what's been marked for identification as states G. Do you recognize this disc?
Yes.
And tell us, what is that disc?
Body worn camera from the day of the incident.
From February 24th, 2020?
Yes.
And you had an opportunity to review this camera prior to coming to court?
Yes.
And that's your initials on the disc?
Yes.
And it fairly and accurately represents your conduct on the body-worn camera?
Yes.
Your Honor, at this time, I'd like to move what's been marked for identification as states G into evidence.
No objection.
Thank you. What was pre-marked as states G will be received without objection as state 6.
In your Honor, request permission to publish states 4.
You may.
Your Honor, may we dim the lights and use the overhead projector?
Yes.
Hello there. Hi. You live here? Yes. Okay, I'll talk to you guys with some information. I know, that's my, the property manager. I don't know if that's still. Tell him really quick, or we'll take care of that. Where's, yeah. And you want that in? Oh, don't worry about that. We'll take care of that for you, okay? I had a cigarette, though. Okay, wait 1 second, okay? I really need something to drink. Okay, well, I got my dog parked on the counter. Okay, we'll take care of you. 1 second. At the time, that you called it? Yeah. That time you called it? Okay, perfect. 20. Go ahead. 707 at 1307. Can't go back to that. What's going on? Who is he to you? Boyfriend? Yes, because like 3.5 years. What happened? We drank last night and had a. Can you pass this to the around to the SD guy? Stop. They need to sign that, sure. Yeah, we're okay. Okay, now leave that. Okay, go. No. Each of them has to. This might be a real thing. But each of them has to put their name. Normally we always. I just put everybody. What's going on? I just got here to fill me in. No problem. Like, puzzle together. We can do some artwork together. You are putting a puzzle together? Yes, we have a puzzle that we started in there. Okay. We've been doing art, trying to put stuff off the wall to make new art kind of there, like having a good time with one another. that we were drinking. We had a bottle of wine last night. Okay. So then it's like, we decided to play hide and seek, right? Okay. So he gets in the suitcase. Okay. Who's that? That's my assistant. My former husband. I didn't, he lived with you guys? No. I told him over here. Okay. Okay. I didn't know what to do. Okay. I didn't know what to do. Okay. So then he came over here. Here, let's talk inside. Okay. I called you guys. I tried to figure out. The problem is, I fell asleep. When did you do CPR? This morning. When I found it before you called. Yeah. 1 o'clock right now. I tried. I was awake, but I actually got out of the bed at like 12:30. I swear. So I came downstairs and I was like, oh, he's in the suitcase still. That's when I found him. I took him out. I tried doing CPR and then I called him and then I called you guys. Did he be here before the fire department got here? Who? Your husband or your ex-husband? Okay. Where did you live at? Right on the street. Okay. So you were playing and who did some updates? I did, but then I fell asleep. Okay, stop. You're okay. I wasn't there. I'm just trying to figure out what happened. Like having an aneurysm or a heart attack or what? What kind of medical condition? None that I know of. None that I know of. No. All we had was a bottle of wine. Literally, just a bottle of wine. Okay. Doing puzzles, artwork. Then we decided to play hide and seek. That's all that happened. Okay. But I really had a heart attack or what in there. Like, I don't know what happened. So how long were you doing CPR on him prior to calling 911? You tried that all morning? Yes. Okay. And then I told him while I was in CPR. Did you start probably, what ballpark? Here, let me fill this at the end, okay? Please, may I have my Dr. Pepper? I am so cutting out right now. Ma'am, and you can't talk to him until we get done with this, okay? Just don't leave, okay, Brian? Thank you, ma'am. Appreciate it. Thank you. I know. Do me a favor. Stand over there by that car. Give me 1 second. There's a dog in there? Yeah. You want to help clear the back bedrooms real quick? Just make sure there's nobody else in here? Nope, he was here with the girlfriend, and that's the girlfriend's ex-husband. He was gonna see it. They were playing hide and go seek is what she said. She's been doing CPR on him all morning before calling us. Yep. So I'm gonna go ahead and start making phone calls. Okay, go ahead. What do I do with this dog? Because I don't want him to mess with him. Come here. Oh, perfect. Okay. Yes. Hey, come on, let's go outside. Come on. Good boy. Cutie. Thank you, brother. But just want to make sure. I put my foot on. Touch anything.
Orange County.
Yes, Doctor. Right over here. Let me check this closet. So garage. That's garage.
All right, I guess we're gonna have to set up a crime scene now.
Oh,
What's that? Karen, Charlotte, Karen, she's like,
just give us a second, okay? It's on the counter. I'm telling you, anything from our house. Look here, let's get you down, because I don't want you passing out. This is probably a lot for you to deal with, right? Water. I can get you some water, okay? Just, I want you not on your feet, because I don't want you passing out. I need to find water. Okay, I'll get some for you.
Your Honor, request permission to publish states 5.
You may proceed.
Let's go ahead and start making the call. Ma'am, could you go ahead and give me his last name, Torres? Spell it for me. Torres. And his first name? George, Jorge. Jorge. O-R-G-E. His birthday? 2/13/78. And this is the boyfriend? Yes. How long? 3.5 years. Living together that whole time? Yes. And your last name? Boone. Spell it B-O-O-N-E. First name? Sarah. S-A-R-A-H. Birthday? 10/10/77. So you kind of think to kind of collect yourself. Tell it to me again. You guys were playing last night, drinking a bottle of wine, putting puzzles together, doing artwork, had a bottle of wine, and they decided to play hide and seek. So what time was that? Do you remember? I mean, I know that I was in bed probably by like what, 12:30? Okay. Well, I went upstairs at least, and I fell asleep, forgetting that he was in the suitcase. Playing the hide and go. Yes. And at some point you put him in the suitcase? No, he got in the suitcase. So he thought it would be funny to be put in the suitcase. So I was like, okay, well, I'm gonna joke with you and I'll zip you up and make him, squirt a little bit, whatever it is. But then I fell asleep. I fell asleep. Where was the suitcase? Right where it is. Right down there? Yes. You zipped him in there? Yes. Thought it would be funny a little bit? It was. We both were laughing about it. Okay. And then I fell asleep. Where did you fall asleep at? Upstairs. In your bedroom? Yes. Okay. Totally forgetting that he was in the suitcase still. Okay. And then you came back downstairs? This morning, or this afternoon, yes, when I got up. What time? 12:30-ish. I was awake, but I totally forgot that he was in the suitcase. He can tell you there's a lot of things that we think of jobs. Yeah, he did tell me. But all that good stuff, so I just totally forgot. So you began to do CPR on him? Yes. Yes. About what time this morning did you start doing that CPR? No, it was the afternoon. It was afternoon because I was awake. But then I finally decided to come downstairs at like 12:30-ish, whatever it is. And I was like, he wasn't moving, nothing was happening. So I unzipped him, took him out and started doing CPR on him. He was on his way over here. I called you when he got here. Once he got here, you called us? Yes. Okay. And air was coming out and he was gurgling, but I could tell by looking at him. But you had to do CPR, you were doing that on your own? Yes. Okay. And then the person that was on the phone with me also, I counted with him doing it. And he's got no medical, he doesn't take any medication? I don't know. I don't know medical wise. I know he doesn't take any medications whatsoever. The only thing, like I said, I don't know if alcohol had to do with it, but we had a bottle of wine. Okay, all right. Here, I want you to sit back down because I don't want. Can I have one more sip of water? Yes, go on. Residential Audible +3 I'll do what I can to get you a cup because I don't want you to have to keep doing that. The cups are like right there. Right here, don't talk to the ex-husband right now. Oh, I won't. Can I have a cigarette, please? Ma'am, I can't take anything out of the house. It's on the back porch. Nope, all of it, secure, okay? I'll try my best to get you what you need, okay? Maybe one of these extras has a pack from someone, sit down and I'll try and get you what you need, okay? Just cut. Okay. I don't want you on your feet. Yes, you put him on the second. He came back in? So there's no thanks then? Corporal, I can give you a rundown? She's, sitting on the curb. Who was? I was getting ready to call you back. Yeah. Want to talk over here?
Your Honor, request permission to publish State 6.
You may do so.
Hey, Sarah. You get enough water? No, you want to stay seated. I don't want you getting lightheaded. So remember I said the detectives were gonna come out and talk to you and go from there. You know what I'm saying? They're here. They're gonna ask you a few questions and then go from there, okay? All right.
All right, Sarah, my name's Chelsea, my partner Scott. It's my understanding you reside here? Okay, is it just you, okay. Your former husband, okay. But you reside here with George and then your son lives with you or lives, there's 50/50? Yeah. Okay. So from what, has told me, she explained, last night that you guys were drinking a bottle of wine, and around midnight, you decided, you guys. Okay. You guys decided to play hide and seek.
Well, we were playing hide and seek and then.
Was your son home at the time or, okay.
No, it was fine. It was fine.
Okay.
Decided to play, we just did it like that, like. Sure. We were putting puzzles together, we were doing artwork. You can see the puzzle that we finished in there and then the artwork and then decided to play hide and seek, just being stupid.
Okay.
So he decided to get in the suitcase, so I thought it would be funny to, and he was talking about it too, to get him up in there. I go upstairs and he fell asleep. So this morning when I woke up, he got me and I actually got up out of the bed. I thought for sure he was downstairs on the laptop, really quiet. But then I came upstairs and I'm like, where is he? Like, and that's when I jumped in.
Okay.
I don't know what happened.
Okay. And then you weren't sure about if you woke up this morning?
It was afternoon. I mean, I was
Or this afternoon?
but I just didn't want to come downstairs. So
Okay.
I just laid in bed for a little while. And then I eventually came downstairs, confused about where he was. And then I was like, oh my God. So I pulled him out and I stretched him out and I started to try to make CPR for him. I called you guys. So I called Brian.
Okay.
And then as soon as he got here, which is 30 seconds on the road, I called you guys.
Okay.
The person on the phone had me do the concussions continually, so I can count with them until you guys shut up.
Okay. And, so as part of our investigation, we obviously have to go inside the house. We have to look at things. Are you okay with us going in the house and looking at things? Okay. And forensics, so we have to have our forensics crime scene investigators come out. Are you also okay with them coming inside, taking photographs and? Okay. Okay.
Can I ask, is Brian, sorry, George, was he diagnosed with any kind of mental history?
Not that I know of. Not that I know of. I don't know. I mean, he doesn't take drugs. I mean, we'll have you take a bottle of wine here and there, but I don't know, like.
Well, that would be my next question. So you guys don't normally drink, you just drink once in a while, or?
Well, I'm gonna say, like, okay, I guess normal drinking is, like, we will have, like, a glass of wine or two, like, while we're eating dinner, or something here, and we'll say, that's working with him. We'll say it's in there. But it's not like.
A couple of beers a day?
I don't understand though, like, for the little bit that we had, like, not having to do it. Like, I don't know if they had a heart attack or a stroke or anything, or what happened. I don't know.
So were you guys together all day yesterday? Okay. Here?
Yeah.
Like neither of you left the apartment yesterday?
I drove up to the store to get cigarettes.
Okay.
But I mean, you can walk there.
Does he have any history of using drugs? I know he doesn't now, because you said he doesn't,
I
right?
don't know.
As far as you've ever known him, you've never seen him?
No. I mean, he's from Philadelphia, and he grew up in Philadelphia, and then he went to Massachusetts, and then from Massachusetts he came down here. So I don't really know, like, a whole lot of, like, medical history or.
How long have you guys been together?
Almost 4 years, like 3.5 years.
You guys been living here the whole time?
Yes.
You've never been to the doctor or to the hospital during that time?
He and his brother got into a really bad argument at one point and had facial reconstruction. But he has been in the hospital from that, and then I talked him into going to see, like, a regular physician, so he could get just like a regular, like, checkup thing.
Yeah.
But there were no red flags.
How long ago was that?
The surgery or
Yeah,
the doctor?
both.
The surgery, I think, was, it was like, 2 years maybe, 2.5 years. The checkup was probably a good 2 years too.
Okay.
And the suitcase is still in there?
Yep, always.
Is it normally stored down there, or did you guys travel recently?
No, he was gonna start picking from, what do you call it? Donation in there, so that's why
it's out?
Yeah.
Okay, you guys did recently travel somewhere and you're like, I'm
After you zipped them up, did you move the bag around and mess with them at all, or you just zipped it up and walked away
I
after?
was laughing about it, but I went upstairs and I fell asleep.
But what position was he in when you went in? Was he sitting on his rear end and his head up and he just kind of
No,
went over?
okay, so like this is the suitcase, like this is his head and then he's right here and his feet were down.
So he was laying on his side?
Yes. Yes.
You just closed the flap and zipped it around?
Yes.
Okay.
I think we were playing.
I understand this, okay.
So he said that I needed to tell you guys about his family, like, who do I talk to about?
We're gonna do that once we walk through and see, yeah, we're gonna.
We're not going anywhere. We're
I'm
gonna
just
be
telling you, like,
Yeah, it's gonna be a
I'm
while.
afraid for my life. I want you to know, I am
Why
afraid
is that?
for my life. His family has never liked me. I'm the blue-eyed white devil, is what they call me. So they've never liked me. They've never taken me in. They've never accepted me. I'll put it that way.
Have you called any of them?
We talked to his daughters yesterday.
No, I mean, like, about this. Is
No.
that- Okay.
That's
So
what
no one's gonna know until we will be making that notification, so
they're going to
it's,
tell me.
okay,
Do
well,
they live local?
Yes, they're down the road. They're going to tell me. His kids are going to tell me in Philadelphia. They're going to tell me. This was not intentional.
okay.
They're not going to understand that. They're not going to accept it.
We're gonna do a thorough investigation. We will definitely make sure that you don't feel scared when we leave here, okay?
And my 9-year-old.
Or he's at school and he's with your husband.
I know, well,
Ex-husband.
Your husband said that, or your ex-husband said he made arrangements for your 9-year-old to be picked up.
Oh, okay, Mom.
All right, we're gonna go inside if that's okay.
Yes, please, but can you guys keep me posted?
Of
So I know what's going on.
Yes,
And don't.
All you have to do is get their attention if you have a question, you need to talk to us. He's standing right there, she'll be right here.
Yeah, okay, but will you guys tell me, like, so you're telling me, like, you won't call whoever it is without telling me, right? I mean, I have all their phone.
We're not calling, we're not making phone calls, we're actually gonna speak to them in person. We
That'll be
are.
later
They're
on.
going, okay.
It'll be later.
Prior to us making any
I'm
calls.
not gonna be here. They're going to tell me,
We'll address all of that, okay, before we leave.
okay? This was,
Okay? Okay.
thank you. Just stay seated, okay, Sarah? I know you're panicking, okay? Just relax. I'm gonna talk to you. We'll keep checking on you.
While you were at the scene, did you also make contact with Brian Boone?
Yes,
Did you take a statement from him as well?
I did.
Were all your interactions with the defendant on that day captured on your body worn camera?
Yes.
I have no additional questions at this time.
Thank you. Any cross-examination?
No questions, Judge.
Is this witness released?
Yes, Your Honor.
All right. You're released, not subject to recall, ma'am. Thank you.
Thank you.
Can the parties approach for a moment? All right, members of our jury, it is 3:21 at this time. We're going to go ahead and take that afternoon regularly scheduled break. I'm going to ask you to come back here in 15 minutes at 3:37. Similar instructions that I've given you previously. Please don't just conduct any independent investigation or research as the person, places, things, or charge involved, and do not have any discussions amongst yourselves or anyone else. I thank you for your service, and we'll see you shortly. Y'all may be seated. Thank you. Bless you. State anything else we need to address?
No, Your Honor.
Defense?
No, Your Honor.
All right, we'll be in a recess till 3:37. Thank you very much. We are back on the record, case number 2020 CF 2603, State of Florida versus Sarah Boone. Let me get appearances for the state.
Dave Castro on behalf of the state.
William J. for the state.
Defense.
James Owens for Ms. Boone.
Tony Henderson for Sarah Boone.
All right. Ms. Boone is still seated at counsel's table, wearing the same black suit and pink blouse from this morning. State, anything we need to address before we bring back in our panel?
Not from the state.
Defense.
No, sir.
All right, let's go ahead and stand and we can bring back in our panel. Thank you. You may be seated. State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes.
Members of the jury, again, if you could please raise your hand, showing that you complied with the court's instructions during our last break. All right, the record reflect all jurors have raised their hands. State, you may call your next witness.
State will call Deputy John Martinez.
Mr. Martinez, raise your right hand, please. Please, do you swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I did.
Sir, good afternoon. Can you state and spell your name for the record for us?
Deputy John Martinez, JOHNMARTINEZ.
Thanks, sir. You may be seated.
Thank you.
You may inquire, sir.
Good afternoon, sir.
Good afternoon.
Tell us, who is it that you work for?
Orange County Sheriff's Office,
And what is your position with the Orange County Sheriff's Office?
Deputy Sheriff.
How long have you been with the Orange County Sheriff's Office?
I'm going on my 16th year.
Prior to working for the Orange County Sheriff's Office, do you have any previous law enforcement experience?
I do.
And where was that?
I first started my career with the New York City Police Department,
And how long were you with the New York City Police Department?
about 10 years.
And what was your position with the New York City Police Department?
I was a police officer.
And at the sheriff's office, tell us, what are some of your duties as a deputy sheriff?
Respond to calls of service. My primary function is the school resource officer.
And is continuing training a condition of your employment with the sheriff's office?
It is.
Tell us, how is it that you became involved in this case?
I was dispatched to this location.
And what was this location?
It was located at 4748 France Lane, apartment number 3.
And is that here in Orange County, Florida?
It is.
And when you responded to that location, who did you first come into contact with?
I came in contact with Miss Sarah Boone.
Do you see Sarah Boone here in court today?
I do.
Could you please point to her and identify an article of clothing she's wearing?
The lady sitting in the middle with the black blazer.
Your Honor, may the record reflect that the witnesses identify the defendant?
Record will still reflect.
during the time that you were on the scene, did you have a body-worn camera?
I did.
And was that body-worn camera activated?
It was.
Were all your contacts with Miss Boone recorded on that body-worn camera?
It was.
Were other deputies also on the scene at that time?
Yes,
And was Deputy Rodriguez there?
she was.
So would both of your body-worn cameras both capture some of the same time frames?
Correct. Yes.
Did you have an occasion to go inside of the apartment?
I did.
And inside of the apartment, what observations did you make?
When I first entered the apartment, I noticed a Hispanic male laying on his back in looks like a small nook dining area. Later identified Mr. Jorge Torres.
Your Honor, may I approach the witness who's been previously marked for identification as states K and been shown to defense?
You may.
Sir, I'm showing you it's been marked for identification as states K. Do you recognize that disc?
I do.
And tell us, what is that disc?
Is a copy of my body-worn camera.
And does this body-worn camera fairly and accurately depict the a portion of the events that took place on February 24th, 2020?
It does.
And are those your initials on the disc?
Yes, they are.
Your Honor, at this time, I'd like to move what's previously been marked for identification as states K into evidence.
Any objections? No objection. What was pre-marked as states K will be received into evidence without objection as state 7.
Your Honor, request permission to publish.
You may. Madam Clerk, can you dim the lights?
coming out now. I'll get you somebody, okay? She wants to say something. She wants to call, come on.
Don't know anything, though, like why or how? So that we will not know the answer to that because we're not. So what's gonna happen? We're gonna go to the doctor's office and they'll have what's called an autopsy. Yeah. That'll be first thing tomorrow morning. I'll know a lot, hopefully a lot more tomorrow morning as far as him. But I cannot, there's no way I can say how, why. So just by looking at him, like, why is he purple? That's normal when someone passes away. But then it needs to be turned.
It's the hard stop speeding. So,
I'm like really scared. I want you guys to know that.
you have all these evidences, so while we're here, nothing's gonna happen. Before we go and make any notifications, you'll have plenty of time to leave or do whatever you need to do, okay? And we've talked about that more than time, right? Yeah, you. We're not gonna be a surprise.
But like, I don't, like, this was totally like not intentional. Like, that's what I'm scared about too. Like,
We'll have all the answers, we'll have a lot more answers tomorrow afternoon. Like you said, what you're seeing here is common. This is us coming out.
Protocol.
Yeah, this age, no real medical history that
I know of.
Where those who have passed away, we come out.
I know. Yeah.
We come out and do an investigation. Medical examiner's office, we send people out, this is what we do. If he was 75 years old and had a heart condition, we wouldn't be here.
I don't know what it is.
Exactly, and that's what we're here to find out, we're just here to get the answers. The answers that you want, the answers that family
I
don't want.
really want to see my son. I really need to see my son. I mean, I know I can't go anywhere, but right. So do I just like sit out here and wait for you guys?
Yeah, you would, yeah.
Does anybody else have you to show up or wait here that needs to be here? My team's here that needs to be here. The medical examiners will show up when we call them, but we're not ready for them yet. So they're gonna take him, they're gonna take some photos, take him, but that's towards the end of it. And they'll be called well in advance when we're ready for them, but we're not ready for them at this point. So we won't be calling them quite yet. Okay? So like I said, I gotta go do some paperwork. They're gonna chat with some people, and then we're gonna come back and talk to you if you're okay with that. So just give us a little bit more time. Like I said, and you don't do that. So, like, do you guys tell his family like today or after tomorrow? You have to. Once our investigation is pretty much complete here, once we leave here, we will be going to.
But again, we'll know, we're not gonna just go and do it without you knowing, we'll know. Talk to you about it, anything like that.
But how, I mean, I understand what you guys and how you do it, and, you know, so, but like, what do you just tell them? What do you tell his parents? Like, what's the reason how it's away?
We tell them what we know at that point.
Yeah.
We tell them the truth.
And that we're gonna be waiting for the autopsy results, and I will get the autopsy in the morning. And hopefully the doctor will be able to give me some of what they think and see.
We'll give them their number, they can contact them, you know.
So yeah, they're gonna know what we're here, what we're investigating, and that they're gonna think I killed him. They always have said that. They've always have said that. I told you it's because I'm the blue-eyed white dragon, that's what they call me, because they don't want him with me. So he's basically just not really been around his family because he chooses me over them. Even after I encouraged him numerous times to go there and see his family. He had to pull her off me one time. Do you have somewhere safe that you can go tonight? Both my parents are unless you run it, that's very local, no. Well, in Altamont, but I think he's doing whatever version he's doing. But the only way. Your phone's inside, correct? Yes. Does he have a phone? No, he does not. He used my phone. He uses your phone. Yeah, the share phone. So the only place I could go is over to Brown's house. But I don't think I have a problem with it. So, well, like I said, we're not gonna leave here. If you do not feel safe, you're not gonna leave here when you're not feeling safe. And then we're like, and then so I'm in Philadelphia. Well, she's in Philadelphia because there's gotta be a funeral, right? That you're talking like days and no, I'm talking right here, right now. So let me do my notification. Let me go do this paperwork that I'm talking about because we can go back and forth about what it's like all day long. I know. So I promise we're not gonna leave here for you and you not feel safe. Right? Please. I don't think you know what to tell you. It's okay. Just take a seat, have some water, give us a few minutes, let us do our thing, and we'll be back to talk to you, I promise, okay?
Let them know.
Okay. Thank you.
Yeah.
Thank you.
You're welcome. Yeah. Okay.
You have anyone in there?
There's nobody here, just me.
Okay, that's fine. You're right there, right?
Yeah.
Sit there, take your fine. I have relief coming, so just leave it.
No further questions.
Thank you. Any cross-examination?
No, sir.
Can this witness be released?
Yes, Sean.
Yes.
Thank you, sir. You're released, not subject to recall. Thank you.
Thank you.
State, you may call your next witness.
State would call Melissa Roughgarden.
Please swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God. Yes.
Ma'am, good afternoon. Can you state and spell your name for the record for us?
Melissa Roughgarden, MELISSA ROUGHGHGARDEN.
Thank you. Counselor, you may inquire.
Ma'am, who do you work for?
I'm employed with the Orange County Sheriff's Office.
And what is your position with the Orange County Sheriff's Office?
Currently, I am a forensic biologist with the forensics unit. Prior to this, I was a crime scene investigator for 5 years.
And how long in total have you been with the Orange County Sheriff's Office?
About 6.5 years.
And tell us all the positions you've held during that time.
Those two, a crime scene investigator and a forensic biologist.
Let's turn to your work as a crime scene investigator. What does a crime scene investigator do?
We respond to crime scenes. We photograph and document those crime scenes through photographs, notes, and sometimes sketches. We collect evidence, we process the scene, and then we do further processing to the evidence back at our forensics lab.
When you say process evidence or process the scene, can you tell us what that entails?
It depends on the scene and the evidence, but it includes the photographs. We also take swabs for potential DNA. We can also do testing for possible blood and things like that. We also process for latent fingerprints, among other things.
What type of training did you need in order to become a crime scene investigator?
Upon being hired with the sheriff's office as a CSI, I completed a 16-week training program, which includes in-house processing as well as going out to crime scenes with trained crime scene investigators to observe and then assist, as well as taking on calls with the trained crime scene investigator.
Approximately how many crime scenes have you processed in the course of your career, in your course of your time as a CSI?
It would be hundreds. I don't know the exact amount.
Were you working in this capacity as a CSI on February 24th, 2020?
Yes, I was.
And tell us, where did you respond out to on that day?
I responded to 4748 Franz Court, apartment 3.
And is that in Orange County, Florida?
Yes, it is.
And when you responded to that scene, whom did you make contact with?
I made contact with the homicide detective, Chelsea Kepsel.
Did you receive information from the detective?
Yes, that it was a death investigation.
Did you walk the scene with the detective?
Yes.
And tell us, what does it mean to walk the scene with the detective in a homicide?
We go into the scene and just observe. We don't interact with anything and discuss what we see.
When you walked this scene, did you see Jorge Torres?
Yes, I did.
And where was he located?
He was located on the floor in the living room of the apartment.
Did you, with the detective, identify potential items of evidence to be collected?
Yes.
You had mentioned previously about documenting scenes with photographs. Was that done in this case?
Yes, it was.
Your Honor, may I approach the witness which has been marked for identification as States M and been shown to defense?
Okay.
Ma'am, I'm showing you what's been marked for identification as States M. Can you take a look at the contents of State M to yourself and tell me if you recognize the items contained within States M?
Yes.
Do you recognize the contents of States M?
Yes, I do.
Tell us, what is the contents of State M?
They are photographs I took on the crime scene.
Do they fairly and accurately represent how that crime scene appeared on February 24th, 2020?
Yes, they do.
Your Honor, at this time, I'd like to move what's previously been marked for identification, the State's M, into evidence.
How many photographs are there? Do you have a total?
111.
No objection.
All right. What was pre-marked as States M will be received into evidence without objection as States 8.
Your Honor, request permission to publish.
You may.
Your Honor, could we have the lights dimmed?
Yes.
And I'm first going to publish to you as part of States M picture photo number 4. Tell us, what is this?
This is the front door to the residence.
States 5.
This is also the front door of the residence, just a closer image to the door.
When you enter the residence, what is the first area just off to the right of the front door?
That would be the kitchen.
Showing you it's been marked as States 11.
Yes, so this is just inside the door. To the right, there is the kitchen area.
Showing you States 14.
Yes.
What is this a photo of?
So this is the counter with the sink in the kitchen. And there's also the open area just above where you can see into the living room.
Showing you from States Composite, photo 19.
Yes.
What is this?
This is a hutch inside the kitchen. You can see in the background, that is where that first photo of the kitchen was taken. So that's the entryway. And then this is the hutch, and there is a cell phone on the hutch in the kitchen.
Showing you States 22.
This is the trash can in the kitchen. You can also see the hutch we were just looking at there on the side.
States 23.
This is the contents of the trash can. You can see 2 wine bottles on the top of the trash.
Did you also find receipts in that trash can as well?
Yes.
Photo 25 from the composite.
These are those same wine bottles and 3 Publix receipts that were removed from the trash can.
Did you take these items and collect them into evidence in this case?
Yes, I did.
Photo 32 from the composite.
Yes, this is just in further into that entryway. You can see the living room.
Photo 35 from the composite.
This is another photo of the living room. You can see the victim located on the floor and a suitcase in the bottom corner of the photograph.
Photo 36.
This is another photograph in the living room. This is that wall we saw in the kitchen there with the opening. You can also see a wooden baseball bat leaning against the wall.
Was that baseball bat collected into evidence in this case?
Yes, it was.
Photo 38.
This is, excuse me. This is also a photograph of the living room, just the other side of the room.
Photo 43 from the composite.
Yes. This photograph was taken in the living room. You can see the stairs leading to the second floor.
Photograph 45.
This is a photograph of the living room just from the other side of the room. You can see the front door in the middle back of the photo.
Photo 49 from the composite.
This is a more close-up photograph of the suitcase.
Photo 50.
This is a photograph of one of the zippers on the suitcase.
Photo Photograph 51.
This is a close-up picture of that same zipper. There is no zipper pull on it. It appeared to be a small wire of some sort, the pink wrapped around the zipper. This is the zipper on the other side of the suitcase.
Just for the record, that's photograph 52. States 53 from this composite.
The close-up image of that same zipper. There is also no zipper pull on that one.
Photo 54 from the composite.
This is the contents of the suitcase after just lifting the lid.
Photo 56 from the composite.
More of a close-up image of the items. There were miscellaneous papers and paperwork, some clothing items, and apparent blood inside the suitcase.
What items, what apparent blood was inside the suitcase?
It was observed on the white cap and a necktie, and there was also visible blood just on the interior of the suitcase.
Photo 57 from the composite.
The contents of the suitcase, but you can see the white cap more clearly and the blood observed on it.
'58 from the composite.
You can see the necktie with blood. It appeared to be silver multicolored. And then there's also a diazepam syringe in the plastic casing there. It was prescribed to the victim.
Photo 61 from the composite.
That is the miscellaneous papers and paperwork that was removed from the suitcase.
Photo 62 from the composite.
That's the suitcase after all of the items were removed.
Photo 64 from the composite.
Yes, that is what appeared to be some like small pieces of paper that appeared to be soaked with blood.
Is this inside of the suitcase?
Yes.
Photo 65 from the composite.
That is the baseball bat that was leaning against the wall in the living room.
Photo 68 from the composite.
This is back to the stairs to the second floor in the living room.
Photo 69 from the composite.
This is moving closer to the stairs to the second floor.
Photo 70 from the composite.
Photographing more of the staircase. These are the steps leading to the second floor before I proceed up to the second floor.
This is photo 71 for the record. Photo 72 from the composite.
The upper portion of the stairs leading to the second floor.
How many bedrooms were on the second floor of the unit?
There were 2 bedrooms.
Photo 75 from the composite. What is this?
This is the hallway. You can see a closet in the hallway and then the door to one of the bedrooms.
Does this appear to be a child's room?
Yes, it did.
Photo 79 from the composite.
This is a photograph within the child's bedroom.
Photo 86 from the composite.
This is the door leading to the other bedroom upstairs.
Did this other bedroom also contain a bathroom?
Yes, it did.
Photo 90 from the composite.
This is the bed within that bedroom.
Photo 97 from the composite.
This is the bathroom.
In that master bedroom upstairs.
Yes.
Did you also have an occasion to photograph the defendant?
Yes, I did.
You see the defendant here in court today.
Yes, I do.
Could you please point to them and identify an article of clothing they're wearing?
She is right there with a black blazer and a pink shirt.
Your Honor, may the record reflect that the witnesses identified the defendant?
Record so reflect.
Showing you photo 98 from the composite.
This is the photograph I took of the defendant.
Why is it that you are photographing the defendant at this point?
I collected her buccal swabs, which is a DNA standard from the inside of the mouth, and it is part of our procedure to photograph that person for identification purposes.
Do you also document the rest of her body as well at that time?
Yes, I did.
Publishing photograph 101 from State's Composite.
This is a photograph of her hands facing upward.
Photograph 102.
This is her right hand facing upward.
Photograph 103.
Her left hand facing upward. both of her hands facing downward, so the tops of her hands.
Photograph 105.
This is her right hand facing downward.
Photograph 106.
And her left hand facing downward.
Photograph 107.
This would be of her right arm.
Photograph 108.
Her left arm.
Photograph 109.
Her right arm with it facing upward.
Photograph 110.
Her left arm with her arm facing upward.
During the time you were interacting with the defendant, did she ever indicate to you that she had any injuries?
No.
You had previously testified that you also collected physical items of evidence from the home as well, in this case.
Yes, I did.
Your Honor, may I approach the witness what's been marked for identification as State C and been shown to defense?
You may.
Ma'am, I'm assuming it was been marked for identification as State C. Can you take a look at that package for me?
Yes.
Do you recognize that package?
Yes, I do.
And tell us, what is that package?
These are the 2 wine bottles that were collected from the trash can.
Is your name on that package?
Yes, my name is on the Orange County Sheriff's Office evidence label that I filled out, and my initials are on the evidence seal from when I sealed the package.
And it also has your agency case number and the location information for this case.
Yes, that is correct.
Ma'am, could you open the contents of States C and look at it to yourself?
I have to pull them out to recognize the item. They're wrapped in paper.
Sure, just how the view from the court. What is the contents of state C?
These are the 2 wine bottles that I collected from the trash can.
Are these wine bottles in the same or substantially the same condition as they were at the time that you packaged them on February 24th, 2020?
Yes, the same time I collected them that day.
Your Honor, at this time, I'd like to move what's previously been marked for identification as states C into evidence.
Any objections?
No objection.
What was pre-marked as state C will be received into evidence as states 9 without objection.
And Your Honor, request permission to publish.
You may do so.
You can unwrap them now. You can put them back. Did you also have occasion to collect the baseball bat from the living room?
Yes, I did.
Your Honor, may I approach the witness who has been previously marked for identification as states B and shown to defense?
You may.
Ma'am, I'm showing you what's been marked for identification as states B. Can you take a look at this item?
Yes.
Do you recognize this item?
Yes, I do. This is the wooden baseball bat I collected from the living room.
Does this item have your name on it?
Yes, it has my name on the Orange County Sheriff's Office evidence label that I filled out, as well as my initials on the evidence seal.
And it also has your initials and your agency case number as well.
Yes, it does.
Ma'am, could you open states B and look at the contents of it to yourself without displaying it to the court?
Yes.
What is contained within states B?
The wooden baseball bat.
And is that bat in the same or substantially the same condition as it was at the time that you collected it on February 24th, 2020?
Yes, it is.
Your Honor, at this time, I'd like to move what's previously been marked for identification as states B into evidence.
Any objection?
No objection.
What was pre-marked as B will be received into evidence as states 10 without objection.
Your Honor, request permission to publish.
You may.
You also had an occasion to collect a suitcase as well in this case.
Yes, I did.
Prior to placing the suitcase into evidence, did you process it?
I took measurements of the suitcase.
What are the measurements of the suitcase?
It was 28 inches in length, 20 inches wide, and 8 7/8 inches deep.
Your Honor, at this time, may the witness step down from the stand and approach the clerk's area.
Yes.
Ma'am, I'm showing you what's been marked for identification as States A. Tell me, do you recognize this item?
Yes, I do.
Tell us, what is this item?
This is the suitcase I collected from the living room.
And how is it that you know that this is a suitcase you collected from the living room?
It has the Orange County Sheriff's Office evidence label that I labeled with the item description. It also contains my name and the agent's case number, and my initials are also on the evidence tape.
Ma'am, at this time, could you open States A and look at the contents of it to yourself?
Yes.
What is inside of States A?
This is the suitcase I collected from the living room.
And does it appear to be in the same or substantially the same condition as the time that you collected it and placed it into evidence?
Yes.
Your Honor, at this time, I'd like to move what's been marked for identification as States A into evidence.
Any objections?
No objection.
What was pre-marked as A will be received into evidence without objection as States 11.
And Your Honor, at this time, I ask for permission to publish States A to the jury.
You may.
Can you open the inside of it? easy is it to operate the zipper that closes the suitcase?
It was a little difficult.
I have no additional questions at this time.
Thank you. Any cross-examination?
Yes, Your Honor. Good afternoon.
Good afternoon.
Are you also referred to as a medical examiner investigator as opposed to just crime scene investigator?
No, that is not my title.
Do you do reports that the crime or that the medical examiner necessarily relies upon in the process of doing the autopsy and additional investigations?
You would have to ask them.
Who makes the decision at the scene as to what items will be photographed and what items will be taken into custody, what items will necessarily be tested or analyzed?
That's a collaborative effort between the crime scene investigator and the lead detective while on scene.
That would be yourself, and who was the lead detective?
The lead detective was Chelsea Kepsel.
Now, you authored a report in this matter, did you not?
Yes,
And that report was utilized, if you in fact know, by the medical examiner in developing her autopsy report, was it not?
I do not know.
In your report, did you advise the medical or whomever might read your report that in fact the body had been removed from the suitcase by first offenders or first responders?
No, I don't believe so.
And we know that you have the capacity to do DNA analysis, correct?
No, we process DNA or collect swabs for DNA, and then that's submitted to the Florida Department of Law Enforcement for conventional DNA analysis.
So you did that with a sample from the inside of Sarah Boone's mouth.
Her buccal swabs were submitted to the FDLE.
And who made that decision?
The detective and I.
Who made the decision not to bother to do a DNA analysis on the blood from the items within the suitcase or the suitcase itself?
That was a discussion between the detective and I.
And you chose not to do that.
No, we did not.
You assumed that the blood inside the suitcase belonged to Jorge Torres, correct?
There was blood observed in the suitcase.
But you don't know who that belonged to because you didn't bother to analyze it or have it analyzed, correct?
The blood was not tested.
Now, State's Exhibit B, the bat, you took that into evidence. Was that again a collaborative decision by yourself and the lead detective?
Yes.
And what efforts did you make to have the bat analyzed, given the fact that it was apparently evidence?
It was just collected as evidence from the scene.
Did you advise either the lead detective or anybody else involved with this investigation that there may be matters that could be analyzed when analyzing the bat that would help or assist in the investigation of this matter?
It's my job to do the documentation and the collection of evidence.
Well, you said it was a collaborative effort between yourself and the lead detective. So did you participate in that decision?
We chose to collect the bat and put it into evidence.
And so there was a fiber analysis done on the bat to determine whether or not it was used to strike Jorge Torres when he was in the suitcase. Was there not?
Pardon?
In fact, there was not, was there? There was no effort to analyze the bat.
I'm going to object. I don't believe the witness had an opportunity to answer the question.
Sustained.
I'm sorry. Please.
Can you repeat the question?
If I can remember it, I will. Do you know that there was any effort made in this particular investigation, the investigation of Sarah Boone, to analyze the bat for fibers?
No, there was not.
And why was that not done?
It was not done.
You indicated that you had some interaction with Ms. Boone. Is that correct?
I collected her buccal swabs.
Did you speak with her?
In collecting her buccal swabs, yes.
Did you speak to any other witnesses?
No.
Did you make any determination of other matters that might be of import or evidentiary value when you were going through the house and taking photographs and documenting
the interior of the townhouse?
You'll have to be more specific.
Well, how many pictures of the child's bedroom did we see?
Here today,
Yes, ma'am.
we saw the entrance to the bedroom as well as a photograph of the interior of the bedroom.
What was the evidentiary value of that?
It's my job to photograph and document while on scene, so the rooms in the upstairs were photographed and documented.
Did you photograph holes in the wall, possibly made by the victim?
I don't recall photographing holes in the wall, no.
Did you take photographs of items within the house or throughout the house that may have depicted incidents of prior violence?
You'll have to be more specific.
How about bloody pillowcases? Did you make any effort to collect and analyze pillowcases of the rooms that you were photographing?
No.
Who made you have significant experience with zippers?
I use zippers regularly, yes.
Enough to have an opinion as to whether or not a zipper is stuck or not.
Is what? Sorry?
You testified on direct that the zipper was a little tight.
Just that it was difficult without the zipper pulls to use the zipper.
And that was your opinion.
Yes, from opening the suitcase here today.
Today, you only tested it today?
Pardon?
You only today have for the first time tested the ability to pull open the zipper on the suitcase?
No, I'm saying it was difficult today.
A redirect examination.
Yes, Your Honor. In this case, you documented the entirety of the house as you saw it.
Yes,
So every room in the house,
they were all taken overall photographs.
walls in the house.
In the overall photographs, yes, they weren't all individually photographed, no.
And you did not document or note any type of holes in the wall or any type of damage to the walls, anything like that.
Not the walls, no.
Is that something that would have been documented both photographically and also within your report?
Yes,
You also, as we've previously seen in the composite, saw the victim where he was laying in this case, correct?
yes,
Was the victim, did he have blood on his mouth and on his face?
yes, he did.
Did he have open wounds on his body?
There was blood coming from his nose and his mouth. There was also some other areas like defects noted on his body.
You also made contact with the defendant too, as well.
Yes,
Did you note any other wounds or cuts or anything else that was not documented that you haven't testified to?
no,
So no wounds, nothing on her.
not that I recall, no.
No further questions.
Thank you. Can this witness be released?
Yes, Your Honor.
Mr. Owens, can this witness be released?
Judge, we'd like her to be on call.
Subject to recall, ma'am. Thank you. Can the parties approach? Members of the jury, thank you so much for your attention in this matter. It is 4:52. At this time, we're going to go ahead and take our recess for the evening. Madam Clerk has letters that I have signed regarding your jury service for you to provide to your employer. Court deputy will provide them to you in the deliberation room before you are released for the day. I have a similar instruction to read to you that I gave you before the lunch hour. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors, do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, I'm going to release you back to the deliberation room for you to receive the paperwork for your employer, and we will see you at 9 a.m. this coming Monday, October 21st. And I thank you for your sacrifice and your service. You all may be seated. Thank you. State, anything else we need to discuss?
Not from the state.
Defense. All right. Thank you all very much. We will see you at 9 a.m. Monday, October 21. We're off the record.